18th, 2018 meeting of the Radnor Zoning Hearing Board. Our first item is the Pledge of Allegiance. I'd welcome you to join us in it. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have one item quickly off agenda as we start. It's the tradition of this board to acknowledge and recognize members who have recently left the board. And I am pleased this evening that Matt Homick, who was a member of this board for 2 years plus up until he resigned this past summer because he and his family moved, and unfortunately for us, they moved to the next township over. And as one of the requirements of sitting on the zoning hearing board is that you be a resident of the township, Matt was forced to resign. But I want to note on behalf of the board how much we appreciated Matt's service, his diligent participation in our activities. He always was very measured in his comments and provided very insightful perspectives that aided his fellow board members in reviewing the items that we were looking at. Additionally, his participation lowered the average age of the board, which we appreciated very much. And we appreciate the fact that his wife and daughter joined us. I'm sure this will be the first of many times his daughter sees him receive awards during his career. So I will be presenting him with this plaque, which indicates honoring Matthew Homick for your dedicated and exceptional service to the Radnor Township Zoning Hearing Board, alternate member 2014 to 2016, member 2016 to 2018. Matt, thank you very much. Moving on the agenda, we have 3 items on the agenda. First item is Appeal 3014. Do we have either the applicants or representatives of James and Leslie Ryan here? The applicant, James and Leslie Ryan, property located at 8 Duncan Lane, request an extension of the time for obtaining a permit under Section 280-144 of the Zoning Code for an additional 6 months to April 19, 2019. Please introduce yourself and be sworn in.
Yes. I do. James J. Ryan. Thank you.
So Mr. Ryan, tell us what's going on.
Yes. So we had planned on using a certain contractor who we gave a deposit to, and found that he was delayed in other work, and so we've gotten our deposit back, have contracted with another contractor, and they were delayed due to the weather. And so we look to start the project in November, but there may be an issue with the contractor finishing up another job and starting ours. So.
Remind us of the nature of the project.
Yeah, the nature of the project is it's a front porch on our home.
Okay. Any members of the board have any questions of this witness? Being none, does anyone want to make a motion?
Mr. Chairman, I move that the applicant be granted a 6-month extension to April 19, 2019 for the previously granted variance.
Is there a second to that motion?
I'll second that.
Any discussion of the motion? Seeing none, all those in favor say aye.
Aye.
Aye. None opposed. Thank you for coming
Thank
in.
you.
Good luck.
Have a good night.
Before we call the second one, this is to share with staff. We've had a series of these, which is fine and could be coincidental, but to the extent you get them from non-residential applicants, caution them that perhaps after the first time we may be doing a more substantive analysis of what's going on, because the fact pattern that could have warranted the grant of the variance could change if a year or a year and a half goes by. I think that's more likely to present itself on a commercial circumstance than a residential, but just keep that in mind.
Absolutely, thank you.
Second item on the agenda, Appeal 3024. Are there either representatives? Okay. Please come up. The applicant, Andrew and Lauren Yorks, property located at 217 East Laurier Place, and zoned R1, seeks a variance from section 280-112.d of the code to construct a swimming pool and appurtenances in the steep slope areas. A variance from section 280-15F of the code to exceed the maximum impervious coverage requirement of 22%. A total of 25.3% is proposed. Counsel?
Good evening. Do we have a handheld? This here? Can everybody hear me? Can you hear me now?
And what is your name?
Great, thank you. Ma'am, good evening. My name is Len Haberman, H-A-B as in boy, E-R-M-A-N. Seated to my left is my client, Andrew Yorks. I also represent his wife, Lauren Yorks, and seated behind us is engineer Tim Blausch. And for the record, Broush, that's B-R-O-U-S-E. May I be seated? Would anybody mind?
However you're comfortable.
Thank you. Members of the board, good evening. I have the pleasure of representing Andrew and Lauren Yorks in this particular request. We are seeking two variances for the purpose of building a pool deck, a pavilion, a shed, and other appurtenances in Mr. Yorks' backyard. The first one concerns a steep slope section, which is 280-112.d as in David. The other is the impervious coverage ordinance, which is at 280-15.f as in Frank. And if it's okay with the board, I'd like to address the steep slope ordinance first, if I may. The first thing I'd like to do is remind the board, and to the extent that the board knows this backwards and forwards, I apologize, but just as a way of reminder, that the purpose of the steep slope ordinance is to protect watersheds, it's to limit increase in stormwater runoff, it's to prevent an increase in landslides. We like steep slopes. They're pretty, and you can graze, and you can have vegetation. We don't live in flatland. And I want the board to understand that Mr. Browse, as well as my client, have given a lot of thought to the issue and the public policy behind why steep slopes are so important and why generally speaking, we don't allow building into a steep slope. However, 280-112 does provide some exceptions to that rule, and one of them is very interesting. It's subsection D as in David 8, and it says specifically, structures customarily associated with the above uses, such as retaining walls and erosion control structures. Why am I highlighting those two phrases? Because Mr. Broush, in a moment, I'm going to ask him questions pertaining to retaining wall. Part of the structure that is intending on being built is exactly for that purpose. And you'll hear testimony from Mr. Broush that actually water erosion, believe it or not, will be, or preventing water erosion will be improved, ironically, by granting of the variance, i.e., there's a greater chance for landslide today with no granting of the variance or without this request being made versus the improved water management situation if the board sees fit within its wide discretion to grant the variance. So that's the first thing I'll mention. I think what I'll do is now discuss the permeability issue, and then this way when Mr. Broush testifies, I can ask him about everything all in one shot. As the board is aware, the ordinance 280-15 F as in Frank says that maximum impervious surfaces are 22%.
We'd like to take that up to 25.3%, so an increase of 3.3%, that's right. That's going to be the pool deck itself. That's going to be the retaining wall itself. And ironically, in order to prevent erosion and landslide, we must increase impermeable land in order to do that. It also contemplates a shed for storage, and it also contemplates a pavilion with a permanent roof structure for some shade as well. Why is that important? The Yorks have two small children who are age, I believe, 11 or 10, 11, 12 and 10. They're going to have to be outside watching. You know, having a structure that's out of the sun, I think, is going to be important, especially in this day and age when we talk about some health risks of sunlight. So that being said, at this point, I think I'd like to call Mr. Browse. Unless the board has any questions now, I'll invite him to step up, and maybe I'll do a small little direct exam and ask him some questions that I think the board might want to have answered. So Mr. Browse, would you step up? Sure. Just check that microphone, make sure it's on.
Hello? Can you hear me?
You'll need to be sworn in.
Sir, if you'll raise your right hand, solemnly swear or affirm the testimony you're about to give will be the whole truth, nothing but the truth.
I do.
And state your name, please,
Timothy Browse.
and spell it for me one more time.
That's B as in Bravo, R-O-U-S-E. I'm principal engineer of Alta Design Associates, A-L-T-A Design Associates.
Mr. Browse, would you tell the board what you do for a living?
I'm a professional engineer.
And how long have you been a professional engineer?
I became a professional engineer in 1996.
All right, so a little bit over 20 years, does that sound right?
Correct.
And during that time, have you had occasion to draw up plans for the purpose of installing a pool, patio, decking, and the like?
Yes, many.
Do you have experience in designing those pool and patio for purposes of water management, retaining walls, and considering erosion, landslides? Do you have experience in that regard?
Yes, I do.
Would you tell the members of the board why you were hired and what you've done so far? That brings us here tonight. And if you want to use your drawing, I'd like you to do that. Does the board have access to the drawings that were submitted? There's one.
Yes, we do.
You're referring to the site plan?
It's called New Site Plan, and the one I'd like to refer to, on my copy, there's actually yellow highlighted version.
Could I ask you to hold 1 second, because I'm going to try to see if we are able to get the screens working, and then, to the extent possible, try to utilize
Great.
the location on the table, which will depict or transmit that, because if anyone's watching at home, they'll be able to see that.
That's a big help.
Mr. Chairman, we probably ought to mark the various exhibits, too.
Sure. Sure, I can mark this as York's 1, if that's acceptable.
Well, why don't we go through,
Okay.
the application would be A1.
Okay, so the application will be A1,
Yeah.
and the site plan we could use as A2.
By Alta Design.
Correct.
Okay, that's A2.
That's the large site plan dated September 14, 2018?
The deed would be A3.
I'm sorry, can you repeat that?
The deed,
The deed A3, yes.
and there is a large, the only other thing I have is a large, nope, I've got two things, okay. It looks though that they may be the same.
There should be some photographs as well. The front of the document looks like this. I'm holding it up.
Yeah.
Two sets? Yes. Two separate sets.
Okay, so,
Maybe we could call that A4, which would be photographs of the subject property.
okay. And A5 would be surrounding?
Sure.
Yes, the A4 is titled as site photographs, and A5 is titled as photographs of adjoining properties.
Correct.
Well, yes. Okay, I've got them mixed up.
All right.
I think you're proceeding with reference to A2.
Correct.
Okay.
Make sure you reference here.
Is the plan that you're referencing a smaller version of this?
Yes.
Okay, thank you. Please proceed.
You can use this if you like the microphone.
So originally, we were hired to design a swimming pool for this project, and the Yorks had desired to have the swimming. Oh, here we go. This was here's a different plan. This shows the where the Yorks originally had hoped to install a swimming pool when we started the project. And as we went out to the site, we did an as-built survey, and we started to show the as-planned as how the client would like to have the project. And as we researched the township ordinances further, we started running into the steep slope ordinance, as well as seeing where we're at with our impervious surfaces. And that is what led us to revise the design of the project and move the swimming pool from up here on the hill down much closer to the house in the flat area immediately behind the house. And we really tried to tuck everything in as tight as we could to reduce the area of impact to steep slopes, so that it just ended up with, we have this one little area of the swimming pool here that ended up still poking into the steep slopes a little bit.
Do you mind if I interrupt for a moment?
Sure.
This area here that we're looking at, that's outlined by my pen, what is that rectangular shape right there?
That is a swimming pool.
Okay. And what are the circles that are next to the rectangle where my pen is now?
Those represent boulders for a boulder retaining wall.
Do those boulders currently exist at the property?
There are some boulders in that
Okay.
general area, but not exactly those ones.
I
but
understand. Is that in a steep slope, yes or no?
Yes.
And there's blue diamonds. Why are there blue diamonds? What are you trying to portray there?
That represents the steep slopes that are in excess of 20%.
Okay. And the boulders continue all the way down the page. What's the point of the boulders being all the way down the page?
They're a retaining wall
All right.
down the page for the project, and primarily they're there to do stormwater management and erosion control for the water that's coming down the hill.
All right.
That these circles here represent drains that will actually stick up out of the ground, and that whole area behind there is going to be landscaped as a rain garden and a stormwater
Okay.
management area.
So right now,
Can I interrupt
Yeah,
just
sure.
for purposes of clarity? The plan you're referring to in this testimony, while it is close to identical to the previously referenced A2, the A2 does not include, for example, the blue diamond reference, okay? So,
yeah, it does. Maybe it's not showing up. We're looking at A2 right now.
well, there's nothing blue on this piece of paper.
Oh, I apologize. Okay.
Yes.
Okay.
It's black and white.
Understood.
So you're telling me that what you're looking at is identical to this, it's just not color?
It's not color, and what's represented in blue on our drawing is represented as triangles on your drawing. In the black and white version, they're blue triangles.
Might it help if I publish this to the board real quick, or not necessarily? Like I can walk up real fast and everybody can just compare it.
Okay.
I know a triangle.
Okay. I think you can continue, but let's try to hold our references to the geometric forms as
To the
opposed to the
triangles.
colors.
And also importantly, that's not in the record. So any references in the record to colors
Right.
is going to be unknown to
I appreciate
folks
that.
looking at it later.
Right. Well, I'll use the word triangles irrespective of color. So, Mr. Brous, my question is this. Right now, is there any retaining wall for the steep slope at the property?
Yes.
All right. How much more of a retaining wall will be there if the board grants the variance request? Approximately.
Approximately 300 square feet.
All right. And will that improve water management of the property versus the way it is today?
Yes.
All right. What I'd like you to do also is where my pen is pointing, there is a corner of the pool that appears to be on the steep slope. I'm asking you, I guess for lack of a better way, is that the best that you can do? Is that the best that this could be drawn? And if so, can you explain?
Yes, we took every effort to get the project out of the steep slopes as much as possible. We couldn't go any further to the south is the primary direction because there's an existing seepage bed over behind the pergola, and there's some trees there that we're also trying to protect and save. And then we couldn't go any closer to the house for fear of putting additional loads on the basement wall. So we're really, and I believe this township has an ordinance that requires a swimming pool to be 10 feet behind a house anyways. So we're really as close as we can get to the house as well.
Okay, and do you know the number of square feet that would be abutting into the steep slope?
I don't have an exact number, but just using my eyeball, looking at the drawings, I'd estimate about 100 square feet.
Okay. All right, if the board will just give me a moment to look at my notes real quick. All right, let's talk about permeability for a few minutes.
Sure.
Was permeability considered when you did your drawing?
Yes.
And what do you understand the importance of permeable land to be?
It would be my understanding that the township's looking to manage the stormwater runoff is the primary purpose of limiting the amount of impervious surface that's permitted in any given site in the township.
Okay. Have you been able to determine how many feet above? So the request tonight is to go from the 22%, which is allowable, up to 25.3%, correct?
Correct.
Have you been able to estimate the number of square footage, not in percentages, but the actual number of square feet additionally that we'd be asking for?
I think that was about 1,400 square feet.
Okay. And on a property that is total, and how many square foot is the entire property, approximately?
The property has a net lot area of 42,750 square feet.
So my estimations tell me that that's the better part of 3%, that 3% of the entire property is the request that we're making, that 1,400 square foot. Am I doing the math correctly?
Right, I think it's 3.3%.
Okay. There is a driveway in front of the property, correct?
Correct.
All right, and does that also account for the permeability? Is that part of impermeable land as well?
Yes.
And what would it take to remove the driveway or to make it permeable again? Would there be expense to that? Would there be effort to that? If a member of the board is thinking to himself, well, why not simply reduce the size of your driveway and then you could increase your percentage of permeability, what would your response to that be?
There would be cost. I would reduce the usefulness of their driveway and really unless all that disturbance was also managing the stormwater, there'd really be more benefit to the township for what we're proposing here, because we are proposing that all this impervious surface is going to be managed through a stormwater management system and a seepage bed in accordance with all the township ordinance.
Can you define what a seepage bed is? First of all, does it exist tonight as we sit here?
There's a little one on
What is a
site
seepage
tonight.
bed, and what do you plan on doing?
A seepage bed is a part of a stormwater management system. Essentially, it's a hole in the ground with pipes and rocks in it that
Okay.
is intended to typically percolate water into the ground and then otherwise release it and slow it down for what it lets go back downstream.
And what do your plans contemplate?
A seepage bed that will be managing the stormwater for all of the impervious surfaces that would meet the township engineer's requirements should this be permitted.
Okay. Members of the board, I don't have any further questions, but certainly the gentleman is here if the board has some questions.
Any members of the board have questions of this witness?
Just a quick question. I'm assuming you were not involved in the design of the pool itself, correct? There's another advisor or professional that's advising the applicant on the design of the pool?
No, we're doing that.
Okay.
It's
Thank you.
Alta Designs doing the design of the swimming pool as well.
Okay. So what consideration was given to changing the shape of the pool so that none of the pool was in the steep slope area?
That was proposed, but this client is asking for a safety cover as one of the appurtenances or parts of the swimming pool, and you need to do a rectangular swimming pool to have a pool safety cover on it.
And to what extent would it reduce the size of the pool to put a rectangular pool in place that did not encroach into the steep slope area?
I'd call that more of a sitting spa than a swimming pool at that point. It wouldn't really be useful for swimming. You might be able to, it'd be a big spa.
I have no other questions.
Is it Mr. Riley? Do I have it correct? Yeah. I think Mr. Riley asked a very interesting question, though, and I think it's an important one. In looking at the map, can you simply take the existing rectangular pool and move it closer to the house so that you're not intruding into the steep slope? I think that's his concern and a valid one. Can you
Well,
Okay.
I worded the question the way I wanted to word it.
Oh, okay.
I wasn't suggesting that the pool be moved closer to the house. So while this might be interesting, that was not the question I was
Oh, no,
asking.
I apologize. I thought that your question had to do with whether the pool could be made smaller.
Yes, that's
Okay.
correct.
Oh, very, very good. Okay, very good.
But if we left the pool in the same location and we tried to get 100% of the swimming pool out of the steep slopes, the pool would be less than half the length because it's touching the steep slopes right around where the G is in the word swimming. So the length of the pool would be reduced to being about half as long as it's shown being now if we were to just try to cut it off to get it out of the slopes. And you can see the dotted line right by the shallow end. There's a rectangular dotted line between the shade structure and the swimming pool. That's the big seepage bed that we're putting in between there. And we had to squeeze that right underneath the pool deck to make it fit. And you can see it's a big seepage bed. We're going to be handling all the storm water that comes in. And because we're picking up all this water that's coming down the hill and not just the water from the pool deck, we end up slowing down even more water. And really, it's going to be a benefit to the township from that aspect.
Any more questions, Mr. Riley? I'm sure the witness will be available if something comes up. and
Sure.
You should continue.
Okay, thank you. I could have just a moment to consult with my client for half a second. after consulting with my client, it doesn't appear that he personally has much to add by way of testimony, unless, of course, the board has some questions for him. If I can have maybe just a couple minutes to make a quick argument on the issue.
Let's see if we have any input from anyone else
Oh,
here.
sure.
Is there anyone here in the audience who wants to be heard on this matter? Okay, seeing none. Do we have any input from, let me step back. I'd ask the owner to be sworn in just to answer
Sure.
one or two simple questions.
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your full name, please.
Andrew Michael Yorks, Yorks.
Mr. Yorks, have you had any conversation about your project with either of your adjoining neighbors?
Yes, I have.
Can you relate that to us?
Yes, Eve Rosen is our next door neighbor. So when you're facing our house to the right, they have a pool, and we've talked to them about it. They went through a process with the town in the past, and they said they would be very helpful in anything they could do with the process of it, and they've been
Please speak
supportive.
up.
And they've been supportive.
And on the other side?
I have not discussed it with that neighbor directly.
And,
But I did send all the letters that needed to be sent, which is a part of the process.
and presumably if we had any letters from neighbors, council would have told us by this point? Okay. Is there, among the photographs that you shared with us, something that you would point to us that kind of gives us a perspective on how this proposed installation would be oriented as compared to your neighbors' properties?
Yes. Okay. So, which exhibit is this?
Can you repeat your question? I want to make sure we answer it back.
I'm trying to get a perspective of the proposed pool as it will be oriented to the two neighbors, either homes or backyards.
Sure. I forget which one this
Okay,
is.
so what you're showing us
This is the,
is the back page of A5.
yes, the site
Okay.
photographs.
I think it's A4 is the site photographs of the subject property, and I believe A5 are the neighbors. I think that's how we.
That's correct.
Yes, but
So on the back of the one with the site photograph, which is this here, so it's what you're looking at here. Sorry, the neighbor's house is over here, and then the other house is, I have to kind of move this, sorry. Their house is much further away. It's kind of over here.
and is it essentially open from your backyard to your respective neighbors?
No.
Or is there a tree line?
There's a tree line and a fence as well.
Tree line on both sides?
Tree line on both sides and a fence on the side with the neighbors who have a pool.
On page 2 of 3 of the top photograph,
Yeah.
you can add probably your best
Yeah.
of exhibit.
You have to use a microphone.
I'm sorry, I keep thinking I'm talking loud. On exhibit A4, I think the best picture is page 2 of 3, the top photograph. I think that's the best view to see where the pool would be, where the existing retaining wall is, where that tree line is that Mr. Martin just asked about, and where the new retaining wall would be. That's probably your best viewpoint, again, which is page 2 of 3, top picture of exhibit A4.
Just to add to that, the neighbor's home on the top photograph would be through those pines. And then on the bottom photograph, you can see the other home. It's sort of back in the distance on the right. And you can see there's plantings and trees back there.
Thank you. Do any members of the board have any additional questions of this witness?
Neighbors in the back.
How far back does it go? And the neighbors that are behind you, have you had any conversations with them?
I have. So it's, the distance to the back is, sorry, it's 140 feet. So, and it's up a steep slope. So, there you cannot see their homes, and there's a very large tree line back there. I have not had discussions with them. They're on another street in the back of the property, but it's very far away.
Mr. Simon, just to interject for a moment. It's on Exhibit A4, if you turn to the very back page, the bottom picture, I think, does a nice job of showing the distance between the Yorks' backyard and where the backyard neighbor would be. It covers quite a distance, if that helps at all. Okay.
And I have a follow-up question about the water. Now, does it flood back there now at all?
No.
Other questions of this witness? Seeing none, thank you. And if you want to share closing remarks at this point.
Great, thank you. I assume the board is well-versed in the case law, and I certainly don't mean to offend anybody if I go through some of the elements. If you know all this, you can sort of smile and let me get through it. But everybody talks about the Hertzberg case. There's the case that came out, Dunn versus Middletown Township, which is interesting because it talks a lot about the word de minimis. And what does the word de minimis mean? Obviously, it means small and minimal and whatnot. But the Commonwealth Court actually discusses, and it says, and I'm quoting, "There is no precise mathematical percentage that marks the dividing line between de minimis and significant deviations." I think that's a fancy way of saying the board has wide discretion. And you can decide that our request for an additional 3% is not de minimis. You enjoy that authority to do that. I, of course, respectfully suggest that a 3% request should, in some circumstances, fall into the de minimis requirement. I understand we're talking about a swimming pool and a patio. We're not talking about building a homeless shelter. That would make this a much more sympathetic request. And I want to be very upfront. We're talking about a beautiful swimming pool in the suburbs. It's, but the de minimis issue, though, and that's the reason why I asked Mr. Broush about the square footage of the pool itself into the steep slope, and I think he said about 100 feet. In my very untrained and unprofessional opinion, I'll make the argument, though, 100 feet of a swimming pool into the side of a steep slope, I would hope falls into that de minimis category, and that if the board decides to agree with me that it is in fact de minimis, that it would not be doing anything that would offend the Commonwealth Court in the Dunn case. And I guess for the record, cite that as 143 Atlantic 3rd 494. It's a 2016 case.
Counsel, you are aware, though, that even if the board were to determine that the relief is de minimis only permits the board to grant relief. A board cannot be compelled to grant relief on the basis of de minimis. The Commonwealth Court is quite clear on that.
Right. That's why I'm trying to use words such as discretion, authority. Hey, Mr. Ryan, the board, I think in theory, could conclude that 0.1% of some request somewhere is not de minimis, and I think that a trial court and a Commonwealth Court would be hard-pressed to overturn that. I think there's a reason why the courts have written the opinions the way they do. They want to give these boards, you gentlemen, wide latitude to do what's right for the community. I agree with you entirely on that point. There are 6 elements to consider when considering the variance request. Of course, we're not seeking a use variance, we're seeking a dimensional variance. And again, I don't mean to bore the board with case law here, but the Hertzberg opinion discusses, I suppose, a more relaxed standard when it comes to a dimensional variance.
Excuse me.
Yeah.
Before, not to cut you off, but assuming that that's the case, what do you make of the specific prohibition in the zoning code for swimming pools and steep slopes? And how is that not a use variance?
The question is one I thought of. Here's my best answer. If it sells, great. If it doesn't, I'm trying here. You know, you're referencing the specific provision that talks about the following uses and no others shall be permitted on steep slope areas. And then, of course, if you go down to paragraph 5, look what it says. You're going to love this one. Swimming pools shall be prohibited. That's difficult. Here's my argument. What it doesn't say, and I'm a firm believer that when the legislature or when the people that write ordinances get together, they know what they're doing, they know the words they're using, and they know the words they're not using. What it doesn't say is that, quote, no part of a swimming pool shall be abutting a steep slope. It could have said that. It says swimming pools shall be prohibited. And then the question becomes, why are swimming pools prohibited? Well, we certainly don't want some big swimming pool on some angle on a steep slope. You're going to have water running out of the pool. And I think that was the thought process in terms of the people that drafted this ordinance. You know, we can't have a swimming pool on the side of a mountain. I don't think, with all due respect to those who drafted the ordinance, I don't think that that sentence there, swimming pools shall be prohibited, was designed to necessarily prevent a variance request when Mr. Yorks is seeking a mere 100 feet of his pool to be into the steep slope.
Let's not conflate de minimis with what appears to be an express prohibition, because I don't see where de minimis fits into prohibited.
No, you're right. It doesn't. I would suggest that when the board makes a decision, that it look at not only the ordinance itself, but also the case law interpreting the ordinances. You're right. The word de minimis is not found at all in the ordinance itself. The case law talks about it, and I think the board has the authority, if it should choose, to read in the concept of de minimis in conjunction with the ordinance. What I did find interesting, though, ironically, and I alluded to this earlier, is number 8 says that structures customarily associated with the above uses, such as retaining walls, railings, and erosion control structures and park shelters. So somewhere along the line, you know, whoever drafted the ordinance decided that, hey, you know what, if somebody's going to build something into a steep slope that is going to be a retaining wall and that's going to help with erosion control, that we will allow. And I find that, I don't know, maybe I'm the only one excited about that. I find that interesting because in Mr. Yorks's plan with Mr. Browse, part of the, if we allow for the variance, okay, and again, I don't want to belabor the point, what I very respectfully suggest is a de minimis request that what the Yorks will be gaining, what the land will be gaining, will be additional retaining walls and additional erosion control structures, which the ordinance specifically contemplates. The last thing I'll mention...
Can I just interject one thing there?
I don't know.
No, we're just going to stick with
Okay.
council.
I guess the last thing I would mention is that, you know, why do we have these ordinances? You know, the ordinance talks about why the ordinances exist in the first place. If all we had to do was look at the ordinance and make a call, yay or nay, then we wouldn't need to have wide discretion to the board. And what specifically it says is that it's the intent of the section to control development of land in areas containing steep slope for the following purposes. You know, why, right? If we're educating somebody on what a steep slope is and why we need to protect it, I don't have to explain it to the board, but the answers are A, to limit erosion and sedimentation, 2, to protect watersheds and limit increase in stormwater runoff, 3, to prevent an increase in the possibility of landslides and soil subsidence, to maintain foliage cover on hillsides and protect streams. Well, 4 and 5 doesn't apply. But what I find interesting is that the retaining wall that Mr. Brausch and Mr. Yorks are contemplating, I think, fits into the intent of the ordinance in the first place. The swimming pool is being designed itself to be a retaining wall. The swimming pool itself will prevent one-off. The retaining wall, it's going to increase inside by several-fold, will help prevent water runoff. So I think, and I'm
Mr.
finishing up here.
I want to bring it back. You were going to go through the 5 elements. Maybe you could
I was.
finish
Okay.
that
And then I'll-
and wind it up.
Sure. The first element says that the zoning board may grant a variance when the following criteria are met. Number one, an unnecessary hardship will result if the variance is denied due to the unique physical circumstances or conditions of the property. Mr. Brausch testified that they considered putting swimming pool at the top part of the backyard, which would be very much into a steep slope. So in the unique circumstances of this property is that it has a circular driveway. We didn't get into testimony here, so I won't testify outside the record, but, and that also, they considered putting the pool at the top part of the backyard, but that was going to abut much too much into the steep slope. Number two says that the property can't be, because of such physical circumstances or conditions, the property cannot be developed in strict conformity with the provisions of the zoning ordinance, and a variance is necessary to enable the reasonable use of the property. So is it a reasonable use of the property to have a swimming pool with the deck and whatnot in this neighborhood? Again, we're outside of the testimony, but had I remembered to ask my client if there were other pools in the neighborhood, if you'll forgive me, the answer would have been yes, there are several. Number three, the hardship is not self-inflicted. There's been no evidence of that. Number four, the granting of the variance will not alter the essential character of the neighborhood nor be detrimental to the public welfare. I hate to be corny about it, but it's a swimming pool, and he can invite his neighbors over and welcome to the neighborhood and let the kids have fun. So the opposite of detrimental, I think, would be wonderful for the community. We need more of that, frankly. We need more neighborly conduct and invites. And I think a pool is we always talk about an attractive nuisance, right? This is an attractive object that will help the neighborhood. And lastly, the variance sought is the minimum variance that will afford relief. And again, that's why I was asking Mr. Brausch those questions about, is this the best that he could do? Members of the board, I can't think of anything else. And we're here for questions, and we respectfully request the variance for the steep slope, section 280-112.d, as well as the maximum impervious coverage, section 280-15.f. I think it's a nice request for a nice reason. I don't think it's going to harm anybody. And you've heard my arguments. And I appreciate all the time and the questions. Thank you.
And you want to move your exhibits for admission?
I will. This time I'd like to move into the record exhibits A1 through A5.
Thank you. To prompt our discussion, would any member of the board like to make a motion?
I'd like to make a motion to discuss it. Is that right?
Robert's rules of order are shaky, but
You want me? I'll take a swing at it. Mr. Chairman, I would move that the relief requested by the applicant from the steep slope and impervious coverage provisions of the zoning code be granted based on the plans and testimony that have been submitted this evening.
I would say.
okay, so now
Would second that.
Now we're going to discuss that. I'll open it up to either you two to go first, if you care to.
I'm not sure that this is an appropriate case for a de minimis variance. I'm not sure that this isn't a use as opposed to a dimensional variance. I'm not sure that the stricter showing for a use variance has been satisfied by the testimony and evidence that's been presented this evening. And I'm not sure the applicant has shown hardship, aside from we can't fit the pool where the zoning code tells us it has to go. So I'm, notwithstanding I made the motion, I'm not sure I could support it.
Scott, do you want to share your perspective?
No, I actually disagree, so
That's okay,
yeah.
disagree.
We're allowed to do
Yeah, okay.
Well, I mean, share,
Sure, I actually
Convince me.
think that it brings value to the property. I think that the community deserves it. I see where they've made a great effort to mitigate any water, and I see where it's a positive project.
and in some ways, I agree with both of you. And I would acknowledge that as a technical matter, under the decisions I'm familiar with, there is probably, it's probably a reach to describe this as a hardship. That being said, I think that there is evidence that significant effort has been made to minimize the extent of the variance and to minimize the impact of the granting of the variance on the public policy issues that these restrictions are designed to address. I think I put weight into the issue of the impact on the community, and I guess my point would be I think that there is essentially no or limited impact on the community given the size of the property and given the size of the property, given the trees as they've been described to us and as we've seen. There's no evidence based on folks here at this hearing or any letters that have been received that there's any objection by the neighbors. It increases value to the property. And it would be my leanings to support the motion. Any further discussion? Seeing none, I'm going to call for a vote on the motion. So the motion is to grant the relief sought. Those in favor say aye.
Aye.
Those opposed?
I guess maybe I do have a question. On what basis is the variance being granted?
I am not suggesting that it be a de minimis variance. I think in terms of the record that we are creating, I would rather just grant a dimensional variance. And while I respect the point you're making about it being arguably a use variance, I would rather it be framed as the grant of a dimensional variance, not based on de minimis considerations.
Remember, that this would be,
John, I can't hear you.
this could be prepared as an order and not get into what kind of a variance it is.
John, I'm going to request it. Well, I'm going to vote against my own motion.
Okay. then I will put
And
it-
I want it specifically noted
Okay.
that this is not a de minimis variance,
Okay.
but that it is.
Do you, would you have anything else in your dissent?
I will draft a dissent, but it will touch on use, it will touch on failure to show hardship, it will touch on the absence of a de minimis variance, and whatever else I can think of. But I'm losing 2-1, so.
Let me complete the voting process. 2 of the members voted in favor. Anyone opposed?
I'm opposed.
The relief is granted 2-1. Good luck with your project.
Thank you, everybody.
It's 7:55. We're taking a break for, we hope, only 5 minutes, and then we will hear the next item.
I know all.
Adjourn for 5 minutes.
I'm not sure what I need to do. You know, some landscapes, but not lots. Most of the landscapes, you know.
My daughter does Title 34. She's a court attorney for Jones Walker.
Okay. In Norham?
Yeah, so
Yeah, okay.
she just made equity partner, and she's like the youngest one. I guess she's been out of law school. For
That's
about-
generally good news.
Yeah.
I have. I'm only handling 5 for now. They probably bring more wisdom to it than most of us do.
I guess. No, we're not. I don't see another microphone. No. Yeah,
We'll find our solicitor, we'll leave on that. Yeah. I need 2.
I will go back into session. The final item on the agenda is Appeal 3019. The applicant, Mark and Fanny D'Onofrio, property located at 15 Arthur Road in Zoned R4 Residential, seek to appeal the zoning officer's enforcement notice dated June 18, 2018, and any other variance or relief necessary for the construction of a fence. Just in terms of clarity for the folks who are here with us, the applicant will be able to make his case. The township is represented, but if there are people here in the audience who want to be heard on this matter, they will have an opportunity to be so heard. Applicant?
I'm going to start with one preliminary matter, and we've marked as Exhibit A26 the affidavit of mailing, and I note to you,
Before we get to that, I would ask you to
identify myself.
introduce yourself,
Yes.
and then I'd like to get Township's counsel on the record identifying himself.
Not a problem. My name is James Tupitza from Westchester, and I'm the attorney for the applicants.
Peter Nelson here on behalf of Radnor Township.
Thank you. Now let's proceed.
And as you said, this is an appeal, so that with respect to that part, the township will go first, and then we'll come with our variance request. But we have an affidavit of mailing, which is A26, and I note to you that the applicant did not mail it in advance, in 10 days in advance of the hearing. So I want to address that, and I also want to address one other thing. She forgot to attach the 2 exhibits to the affidavit of mailing, which is the notice and the list of people to whom the notices were mailed. So I'd ask leave to be able to substitute that later and provide that. But the notice that was sent out was the notice provided by the township, and the list of people to whom that notice was sent was the list of people provided by the township, and every one of them got the notice. when she first got the box of things, I'm talking about Mrs. D'Onofrio, I was out of the office, and she believed that she needed to send these by certified mail, and when she did the calculations of that, she thought that was going to be $4,000 or $5,000. We got that straightened out, but that was after the 10-day window, so the mailings went out last Friday. I note to you that the municipalities planning code doesn't really have any date requirement with respect to giving the notices. Your ordinance is more restrictive and stricter, but if the notices were not given properly, it does not modify the relief that a board can give. It only puts the applicant in a position that one of those people that might have gotten the notice 3 days later than they should have under your ordinance, that they have the right to an appeal. Most of the people in the box of envelopes that we were given were in the 2 big high-rise apartment buildings behind this property and not in the neighborhood. And those were homes in New York and California, Florida, all over the place, because I'm assuming they're people that own an apartment, have a college student living in it, and go through that process. So I've consulted with the township solicitor on this, and he and I are in agreement that this doesn't put the board at risk or the township at risk. It just creates a potential risk that my clients are willing to assume that one of those people that didn't get the notice within the 10-day period can go argue to the court sometime that they have the right to appeal later.
One question, if you know the answer, you can answer it, or perhaps your client. When they were mailed on the 12th, can you describe to us, were they deposited at the post office? Were they put in a box? What were
Yes,
they done?
they were taken to the post office, and in fact, they filmed doing it.
The post office, either in Villanova or Bryn Mawr, the proximate post office.
Yeah.
Thank you.
Yeah. In fact, and
okay.
they were recipients of one of the notices, so they got it in the mail.
And Mr. Nelson, that accurately describes the township's position on this?
Yes, that is the township's position.
All right, we'll proceed. We'll proceed, and Mr. Nelson.
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record, please.
Kevin Kachansky.
Good evening. Once again, Peter Nelson here on behalf of Radnor Township. Mr. Kachansky, just to start off with, can you provide the board, and this is for the record's sake because I'm sure the board already knows this, just quickly your educational and employment background?
I have a Bachelor's of Science from Temple University in Landscape Architecture. I've been involved in municipal work since I graduated in 2000 and have been employed with Radnor
Can you use the
Township.
mic?
I've been employed with Radnor Township since 2011.
And your position at Radnor Township, what is it?
The Director of Community Development and the Zoning Officer.
And what are your duties as the Director of Community Development and Zoning Officer?
To enforce various codes of the township.
And is one of the codes you have to enforce the zoning ordinance?
Yes.
In regards to this particular application, can you brief?
Mr. Nelson, just one quick second.
Yes.
I don't see in the applicant's index the enforcement notice. I have copies of the enforcement notice here. Do you wish to introduce them as an exhibit, or should the board introduce them as an exhibit?
I have copies that I was planning to introduce as an exhibit.
Okay.
Mr. Kuchansky, just to give the board some background in regards to your familiarity with this particular property on Arthur Road, can you kind of explain the history that led up to this issue with the fence?
Sure. There was an issue on the adjacent property. I believe it was 17 Arthur Road, where it was brought to our attention that work was being done without permits. So staff was contacted. We investigated the situation, realized that work was being done without permits, and worked with that property owner to apply for the necessary permits to come into compliance with the codes. Upon doing that, subsequently, the D'Onofrios applied for a fence permit, installed the fence, and one of my site visits at 17 Arthur to finalize the location of an air conditioning unit. The neighbor at 17 Arthur pointed to the fence and asked if that was in compliance with the height regulations and location.
Okay. I'm going to hand to you a document that I'm going to ask to have marked as Exhibit T1. Mr. Kuchansky, can you please identify that document that's been marked as Exhibit T1?
Yes, this is a application for a building and zoning permit that was completed by the D'Onofrios for the fence.
And this is the fence that is at issue?
Yes, it is.
And what kind of fence did they propose to construct in this application?
On the second page, it says a 4 to 6 foot high, 4-rail, split rail, probably locust post and spruce rails or equivalent fencing with 2-inch by 4-inch 14 gauge galvanized wire, a gate post, probably 6 set in concrete footers.
Okay. Is there a further description of the fence that's contained within this application?
There was a contract, a proposal / contract provided by Rusticraft, the contractor that was installing the fence. There is a description of the fence in that proposal.
And could you read what it is listed under quote-unquote job description, please?
Install 362 feet, 4 foot high, 3-rail, split rail, locust post, and spruce rails, fencing with 2-inch by 4-inch 14 gauge galvanized wire. Gate post 6 set in concrete footers will be installed by customer.
And the listing of the 4-foot high fence, is that in compliance with the township zoning ordinance?
Yes, it is.
And what does that zoning ordinance require for a property within this zoning district?
This zoning district is in the R4. This property is in the R4 zoning district. There are special regulations. Typically, fencing can be 6 foot high, but within the R4 and R5 district, fencing located in the front yard setback can only be 4 foot high.
Looking further at the proposal contract from Rusticraft, there's a plot plan that's also as part of this proposal, correct?
Yes.
And on the plot plan, does it list, not the site plan, but the plan for the fencing to your left? It's on the same, page. Does that list the distance the fence runs will be on the side yards?
Yes. There are 2 dimensions. One's blacked down. I believe that was highlighting, but it's 113 feet on the left side of the property.
And how about, do you believe on the right side that it was the same dimension?
My recollection was that it was the same dimension on the right side.
And then turning to the second to last page of Exhibit T1, this is a site plan of the property?
This was a site plan that was also provided with the permit application.
Okay. And in this regard, I'm going to hand out a document that I'm going to ask to be marked as Exhibit T2.
A quick interruption. Is there a way to have items projected here? It seems like they were earlier. Thank you.
Thank you. This is T2.
And Mr. Kuchansky, could you please identify for the board what exactly T2 is?
This is a larger copy of the plan that was submitted with the permit application for this residence, 15 Arthur Road.
And does this Exhibit T2 show the dimensions of the D'Onofrio's lot?
Yes, it does.
And what are the dimensions of the two side lot lines?
The left side property line is 133.06 feet. The right side property is 135.00 feet.
And based on these dimensions, as well as the dimensions submitted with the proposal from the fencing contractor, did you make any determination of how the fence was going to be located upon the property?
Well, on the site plan also shows the right-of-way of Arthur Road, which is dimensioned as 40 foot from right-of-way line to right-of-way line. So the half width of that would be 20 feet. If you take that 20-foot half width, subtract it from the 135 feet, you come up with about 115 feet on the right side and 113 feet on the left side. Those dimensions match the dimension from the contractor on the proposal of 113 feet of fencing on the left side of the property.
And the contractor's plan, it doesn't show any of the right-of-way of Arthur Road, does it?
No, it does not.
And does it show any of the dimensions of the lot?
No, it does not.
It just shows where the dimensions of the fencing.
Correct.
But based on that diagram and on the site plan, you determined that the fencing was going to be installed outside of the right-of-way.
Yes, if you look at the dimensions of the site plan, 133 feet on the left side minus the 20-foot for the right-of-way, you would get 113 feet. So it would indicate from the plan and what was submitted that the fence was going to be installed outside of the right-of-way.
And you mentioned that on a site visit to a neighboring property at, I believe, 17 Arthur Road, you were asked to look at the installed fencing?
I was out there to verify the location of an air conditioning unit that was violating the setback, and at that point in time, it was brought to my attention the fence location. It was clear because there were survey pins in, as well as the height.
And what, if anything, did you see when you looked at the fence?
I was able to see from being on 17 Arthur and then from the front that the fence had been installed beyond the rear, left rear property boundary indicated by the survey marker, as well as on the front two posts, the front right-of-way along Arthur Road, that the fence was installed within the right-of-way.
And Mr. Kuchansky, I've just handed you a document I'll ask to have marked as Exhibit T3. Could you please identify that document as I hand it out?
These are site photographs that I took on one of my site visits out there when it was brought to my attention when I took my measurements to confirm that the fence was in violation of the Township Code.
And looking at the first photograph on the top page, can you please explain what that photograph depicts?
That is the frontage along Arthur Road. It's the right front property corner. The stake with the pink ribbon on it is the survey pin for the right-of-way line, separating the right-of-way from the property area.
And let's just step back 1 second. Who took these photographs?
I took these photos.
And do these photos accurately depict what you saw out on the property at the time you took them?
Yes, they do.
And going back to that first photograph on the top of page 1, there's a stake there with a pink flag on it. What does that stake show?
That stake is a indicator for where the pin is for the property corner.
Mr. Nelson, I'm sorry.
yes.
Can we put those on the table so that they can get them on the screen there? If you've got an extra copy, I know that'd be helpful. Thanks.
Can you work off of that, Kevin? Okay. And to the left of that stake, what is that area?
To the left there is the front corner of the post, and then the concrete is the concrete sidewalk that extends along Arthur Road.
And so is that, to the left of the stake, does that constitute the right-of-way for Arthur Road?
That would be the right-of-way area of Arthur Road.
And to the right of that stake, would that be the D'Onofrio's property?
Correct.
And then the lower photograph, what is that showing?
That is a picture depicting the height of the post, part of the fence, all along that same corner in the front, and it shows where the 48-inch mark is, the 4-foot mark, midway through the top of the rail, and then the top of the post being about 55.5 inches.
And what is the required height for a fence post in that area?
Again, in the front yard area, assuming that the post would be moved back into the property outside the right-of-way, would be 4 foot.
So it exceeds that by about 7.5 inches?
Correct.
Turning to the next page, there's a single photograph on that page at the top. Can you explain to the board what that photograph depicts?
Yes, this is the left front property corner, again showing the dimension of the post, the height, again at about 56.5 inches, maybe a little bit more than that. And you can see the survey pin, but this picture was taken primarily to show the height of the fence being in violation of the 4-foot requirement.
And once again, this is a post at the front of the property.
Correct.
And this post was also within the right-of-way.
Yes.
And this post also should be 48 inches tall?
No greater, any portion of the fence should not be greater than 48 inches.
The third photograph, it seems that the intrusion into the right-of-way is kind of at a slant. There's very little intrusion on the third photograph that you showed, and a lot of intrusion on the first photograph.
But this picture wasn't intended to show the intrusion to the right-of-way, just the height required. I think there's other pictures that show the intrusion to the right-of-way.
Yeah, Mr. Ryan, actually, the next picture will give you a more accurate depiction of how far it goes into the right-of-way.
Okay.
So if we can turn to the next page, the next picture on the left-hand side, can you please tell the board what that picture depicts?
This is the picture that front post that we were just looking at, but the left front of the property, and you can see to the left of this picture the survey stake indicating where the pin is for the property. To the right of that stake would be the right-of-way, to the left would be the property.
And so this picture depicts the fence being 2 to 3 feet within the right-of-way?
Yes, it does.
And then the last photograph on the right-hand side of this page, what does that depict?
This is the rear corner standing on the property of 17 Arthur. You can see this stake with the yellow ribbon on it. You can even see the rebar of the property corner. And what this shows is that the fence has been installed off of the property onto the adjacent property.
So can you please explain what properties to the left of the survey marker and what properties to the right?
To the right would be the D'Onofrio property. To the left would be Rosemont Plaza's property.
And what steps, if any?
Question. What was the process by which there's a survey marker here? This was not something the township did, presumably?
That was not something the township did. I believe that was something that the D'Onofrios engaged in.
Thank you.
And what actions, if any, did you take upon observing these characteristics of the fence?
I noted the issues. I confirmed that there were violations of the code. Then I reached out to Mr. and Mrs. D'Onofrio and advised them of this via an email and noted that it was a courtesy notice highlighting that the fence had been installed in violation of the code and requested that it be corrected.
Mr. Kuchansky, I'm going to hand you a document that I'm going to have marked as Exhibit T4. As I hand it out, if you could please explain to the board what this document is.
This is an email that I sent on Friday, May 18th to Mr. D'Onofrio, and I copied the township solicitor on it, updating Mr. D'Onofrio that I had met with the neighbor regarding the proposed location of the air conditioning unit that needed to be relocated, and that a code-compliant location for that air conditioning unit had been identified, and that they were going to take about 2 weeks for that work to be conducted. And then I also noticed him in this email that I observed that there were some issues with the fence and identified what those issues were. And then the final paragraph is, indicating that it was a courtesy notice and to contact me to let me know how the violations would be corrected.
So this is the courtesy notice you had just previously mentioned.
Yes, I typically on enforcement matters like this don't go straight to a violation notice because that can set the wrong tone in trying to work with our residents. So I always, not always, but I typically try to send a courtesy notice either via email, if I have email communication, or via a letter, but similar in format, noting that it is a courtesy notice.
And what response, if any, did you receive from the D'Onofrios regarding this courtesy email?
There was an email that was sent to myself and I believe the entire Board of Commissioners identifying a variety of issues and threatening, in essence, a lawsuit against the township.
And what further steps, if any, did you take after issuing the courtesy notice?
I allowed for the expiration of the time period for Mr. D'Onofrio to come into compliance and to contact me about how they were going to, and then I issued a formal violation notice.
Mr. Kuchansky, I'm going to be handing out a document that I'm going to have marked as Exhibit T5. If you could please tell the board what this document is while I hand it out.
Absolutely. This is an enforcement notice that I issued to Mr. and Mrs. D'Onofrio. It's dated June 18th, actually 30 days after the courtesy notice was sent, to provide them with plenty of opportunity to come into compliance. And it identifies the specific zoning sections that are in violation, which mirror the sections that were noted in the, or the items that were brought to their attention in the courtesy notice.
And under this enforcement notice, can you please tell the board exactly what the D'Onofrios were cited for?
The specific violations, there were two. The first one, definition of fence. A fence or wall is defined as a structure designed to enclose a lot or a portion of a lot or to separate a lot from an adjoining lot or right-of-way. Based off of the survey markers that were noted on the property, the fence had been installed within the Arthur Road right-of-way and on the neighboring Rosemont Plaza property, and that was a violation of the Municipal Code of Radnor Township. And then the second notice section that was noticed, section 109, fences and walls, talks about the height of the fence or wall within the R4 and R5 district should not exceed 4 feet. And I note that there were portions that were located within that 30-foot front yard setback that exceeded the 4 foot.
And these violations you cited in Exhibit T5, the enforcement notice, those are the violations that you observed on the D'Onofrio's property and that you then illustrated in the photographs that have been entered in as Exhibit T4.
They are.
Okay. Thank you. That is all. I reserve the right to recall Mr. Kuchansky as a rebuttal witness, depending on the testimony provided by the D'Onofrios.
Thank you.
Thank you.
Uh-oh. What happened to this thing? It suddenly went, uh-oh. It gave me a Control-Alt-Delete. Hopefully I don't need a password to get in. Yes, I do. Anybody know what it is?
People just appear.
Yeah, it was there. Oh, now, how did I get back? Okay. That's wild. I'm not sure how that happened.
Your mere presence.
Terrified.
Please proceed.
Okay, couple things first. You, in your enforcement notice, T5, you indicate that the calculations, at least as to the location of the fence, are based on the survey markers, correct?
Correct.
And were you there when the surveyor was doing the work?
I was not.
Do you know, the markers that you're talking about are wooden stakes in the ground with flags on them, are they not?
There are wooden stakes in the ground with flags on them. There are also iron pins that are also present.
Did anybody, was anybody there to explain to you what the wooden stakes represented?
I don't need that explained to me.
And you don't need that explained to you for what reason?
I previously worked for an engineering consulting firm that had a surveying department, and I understand when a surveyor goes out and they find the pins that they put wooden stakes in the ground to identify the corners of a property.
If the surveyor was not asked to identify the corners of the property, but rather just to set the sidelines of the property, would your opinion then not change?
Well, it would not change because I measured from the center line of the road to the stake and came up with about 20 feet, which would be representative of where the right-of-way was.
Okay, now you know that the D'Onofrios have asked for a variance to enable them to keep that fence along the edge of the sidewalk, do you not?
I don't know that there was a specific variance request for that section.
But if the board were to grant them a variance to allow that particular fence to remain located at the edge of the sidewalk, can you think of anything that would give, anything that might cause to be injurious to the health, safety, or welfare of the community?
Well, it impedes right up against the public thoroughfare of the sidewalk. So yes, somebody could be walking along and walk into the fence because it is so close to the public thoroughfare.
But you've seen along this street, the other properties all have large.
I'm going to object. This is beyond the scope of direct. If they're going to put on testimony regarding a variance, Mr. Kuchansky is going to be responding to that testimony, and then these questions could be brought up then. But right now, we're just dealing with the enforcement.
Sustained.
Yeah, I meant to get it all together. I'll stick with the order, that's fine. So when we're talking about the height of the fence, you'd agree with me that the 4-foot sections, or that the pieces that you're talking about that exceed everything by 4 feet, and I'm going to try to jump to, I'm going to show you Exhibit A7, if you can look up on the screen. I have A7 there, do you see that?
Yes.
You'd agree that the horizontal portions of the fence on this property are at 4 feet?
I would not.
And did you measure them?
Yes.
And you thought that they were more than 4 feet?
Yes.
And how much more than 4 feet?
If we refer back to Exhibit T3, the second photo, you can see that the middle of the top rail is at the 4-foot mark, and being an uneven split rail fence, it could be 2 to 3 inches in height along that section. You can also see on the third picture that it's closer to the bottom of the top rail is at the 4-foot height. So the top rail is in violation of the 4-foot height.
So it's that top rail, and it's the vertical post, is that correct?
Correct.
Could we, these photographs, if we're going to keep referring to them, I'd like to break them down in T3A, T3B, T3C, and
that makes
so
sense.
we all understand what photograph. So the first one is T3A. The one on the bottom of the first page is T3B. The one on the next page, which is by its lonesome, is T3C. The next page is, the top one is T3D. The following the photograph at the bottom of the next page is T3E, and that, I think, covers it. And so we can...
So when you did the measurements that are shown in T3B and T3C, those are the only places that you have exhibits that show what the height of the upper rail is that correct?
That we have as exhibits, correct.
Okay, so you don't know what the height is for any other areas other than that for which you have exhibits?
Not at this point in time, no.
Okay. That's all the questions I have.
Thank you.
Just one point of clarification, Mr. Ryan. On the last page,
I'm sorry, Mr. Nelson, use the microphone for benefit.
on the last page of photographs,
Yes?
if you, since those photographs are oriented than the photos on the first page, I just want to make sure. The photograph that's depicting the front yard, you see the sidewalk and the road. On the left-hand side, that's E. And then the photograph that depicts the backyard and you see the stake and the pin, that is D. Is that correct?
Yeah. Or put it the other way, top one is D and bottom
Yes.
one is E.
Okay, yes, okay, I just want to make sure. Okay, thank you.
I did have one other question. When I look at Exhibit T3D, do you know for certain that that pin is the back property line of this property?
I don't know for certain. I know that survey stakes are located at property pins.
You'd agree with me, you've done a lot of survey work, that when you're out surveying, sometimes there are pins that are in corners, there are pins that have been moved, there are pins that relate to other surveys that may be along lines of property. You'd agree with that, wouldn't
Well,
you?
I wouldn't agree that I've done surveying work because I'm not a qualified surveyor.
But you
I'm
reviewed-
experienced and familiar with surveying practices.
And you'd agree with me that there are often pins that are located places other than at the corners of property.
Possibly, but typically they are at corners.
But you don't know for a fact that that pin on T3D is at the rear property line of this property, do you?
No, because I did not do the survey.
Mr. Nelson, what else do you have for us?
Mr. Kachansky, in regards to the pins in the front of the property, you stated that you actually measured from the center line of Arthur Road 20 feet into the D'Onofrio property to see if the stakes approximated it at 20-foot right-of-way?
Yes, I was concerned for the exact reason that that stake would not necessarily represent the right-of-way. So when I was out there to confirm that, I put the tape measure to the center line of the road and measured out to the stake, and then from the stake out to the center line of the road and measured around 20 feet.
So if that stake is not exactly at 20 feet, it's a very close approximation.
Close enough for me to make a logical conclusion that that was the right-of-way line.
And as far as the height of the fence, is it only certain aspects of the fence that must not exceed 4 feet, or is every portion of the fence prohibited from exceeding 4 feet?
Any portion of the fence should not exceed 4 feet.
And other than the two post measurements that you show in the photographs, did you measure other portions of the fence?
I don't recall if I measured other posts. If I were to measure other posts, it would have more than likely been at the front of the property, as shown up on A7 at the front walkway, but I don't recall what those measurements were.
And if those other posts were 4 feet or under, would they be in compliance with the ordinance?
If the posts were under 4 feet, they would be in compliance with the height aspect of it, but if they were still in their location, they would be in violation of the right-of-way.
And so if those other, as far as height goes, if those other posts were height-wise conforming, that just means that the D'Onofrios would just have to fix these particular posts to bring them into conformance.
Yes.
Thank you, that is all.
I have no further questions.
Mr. Nelson, do you have anything else to present to the board?
The township rests its case as far as the enforcement notice goes, and I ask to move the township's exhibits T1 through 5 into the record.
Thank you. Mr. Pizza?
On the defense of the township's case, I'm going to call Mr. D'Onofrio, but just with one question, but if you can stand and get sworn.
Mr. D'Onofrio, come over to the microphone, please.
Oh, yeah.
Which one should I?
Either one.
Hello? Hello?
Raise your
Yeah.
hand.
Yeah.
Solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth.
I do.
And state your full name.
Mark Edward D'Onofrio. Can I just test this once?
You're the owner of the property,
Yes.
and you hired the surveyor?
Yes, I did.
And did you ask the surveyor to locate the corners of the property?
We did not.
What did you ask the surveyor to locate?
We were actually looking at the side properties. We didn't want to encroach on the spaces of our adjacent neighbors. So,
No further questions?
On this point, any questions, Mr. Nelson?
Mr. D'Onofrio, do you have any evidence that the stakes don't portray your corners of your lot?
Objection, he doesn't have the burden to prove that.
Can you phrase
He
it?
asked the I mean, he can answer the question, and then we'll take it for whatever weight. Please answer his question.
Okay. Can you phrase it in a positive way?
Do you have any proof? Wait, hold on one second. In a positive way. So are you testifying that these stakes do not depict the corner of your property?
I'm not qualified to make that assessment.
So
I
you-
did not hire the surveyor to do that work, the work
But-
that you suggest.
But you don't know if as part of the work he was hired to do, he did not actually demarcate the corners of your property.
Can you say that one more time?
You do not know if the surveyor you hired actually demarcated the corners of your property in conjunction with doing the work you hired him to do.
I don't think so.
One second. So, and so you have no proof that the stakes depicted in Exhibit T3 do not show the corners of your property.
I hired.
Do you understand the question?
No, he keeps on phrasing in negative.
You had two negatives in there, so I got lost in it.
Yeah, I'm kind of getting lost the way you're phrasing it. I just don't know where you're.
You're alleging that the surveyor, you're implying, since you did not hire the surveyor to demarcate the corners of your property, that your surveyor actually did not do that.
Let me make this easy. We'll stipulate.
Mr. Nelson, that was not a question. I think from this board member's perspective, it's pretty clear what he has testified. If he had documentary support to what he's testifying, I'm sure it would have been provided. He stated what he stated on the record, and we've heard that.
We'll stipulate that he hired the surveyor to locate the sidelines, and he doesn't know what he did with respect to the corners, doesn't know, doesn't have any evidence one way or the other on the corners. So.
Thank you. That is all.
Please proceed.
Okay. That's all of our case against the township's case, but now we have a request for two variances, and let me outline what they are. The first variance request deals with the height of the fence, the 4-foot minimum or maximum height. We believe we're going over that by a de minimis amount. I'm not going to repeat the Dunn case and everything that we heard in the prior hearing, but that's a dimensional variance. That's a de minimis issue. And we're also asking for a variance for the location of the fence, because even if we assume the township is correct, that the fence is within the front yard setback and in the right-of-way, we're asking for a variance for that because it is replacing bushes that were not only in that area, but were encroaching further into the setback area. And you'll hear the testimony with respect to that. So that's really essentially two variances. One to allow us to be in the front yard, one to allow the height to be what it is at. If necessary, well, I'm not even going to mention the one in the rear because we don't believe we're encroaching into the rear, and I don't think there's any testimony that satisfied that or dealt with that clearly. So we're going to simply deal with our request for our variance, and our first witness is going to be Fanny D'Onofrio. And Fanny, if you can take that microphone stand and you get sworn in.
Just 1 second. I'm a little lost. How do we give a variance for intrusion into a township right-of-way with the township opposing it?
Because of the testimony that we're going to present. We'll present testimony that it is it's a dimensional variance, that it is
But
not in juris-
it's on their, the
It's-
township's
it's-
property.
Well, it's within the right of within the right of way. Their fee goes to the center line of the road, so the township has a right of way over that, but they own the fee.
But is that a zoning issue or an issue of property rights? I mean, it strikes me that this would, in some jurisdictions I'm familiar with, more customarily be handled through a license agreement or other agreement directly between the property owner and the municipality to allow for that use.
In the city of Philadelphia, as you know, that's the most common way of dealing with it. I look at it as really two different things. I look at it as zoning and property rights. So under a zoning provision, there's something that says that we can't put the fence in that particular area. Okay, so we want a variance from that. If the township then says, hey, this is later and outside of you folks, we don't want you on this property and we have property rights, then it's the subject of the same kind of thing you've talked about. And I've done many of those in the city of Philadelphia where you have steps or air conditioning units or things that encroach out into the rights of the streets in Philadelphia and other towns as well.
One of the things, this board admittedly has no jurisdiction to try issues of title. If there is a
Right.
colorable claim to title, that's not us. But we have to have some claim of title, and if you clearly are in the right of way, I don't see where your colorable claim to be there is. It's not as if you're saying, well, he says I own this and I say I own this and let us go fight it out on quiet title. This is the township right of way, and I'm a little lost as to how we can say, yes, it's the township's right of way and we have no colorable claim to be there. But we're going to let you be there.
Here's where our claim to title is. Exhibit T2 that was put in by the township. It's the survey for this property and shows that this property goes to the center line of the road. Now, that means that we own the fee simple absolute to that point, subject to the right-of-way of the road and the sides of the road, and that right-of-way of the road is 40 feet. But that is... That's something that lays on top, like an easement, although public in nature, that's something that lays on top of the fee simple. If we look at Exhibit T2, it shows right where our property lines are, and it goes out to the center of the road. That gives us the colorable claim to title. The township then can say, we admit that they have a right-of-way that comes 20 feet our way. They can then, in a different forum, say to us, hey, you're on our property, and then we deal with that with a license agreement or something of that nature. But from a zoning point of view, we're here because the zoning ordinance says that we can't do such and such, and we're asking for relief from that.
Mr. Ryan, how long have you been a solicitor? How long have you been the solicitor of the board here?
19 years.
Do you have any recollection or experience of a similar circumstance where the board granted relief in the character that council is seeking?
No. It doesn't come up very often, but there was one case where it did come up where the township right-of-way abutted the property, but the township wouldn't let them in, and the underlying fee of the abutting thing was in a different development. And that was one of the two reasons that we denied it for want of in that sense, for want of jurisdiction.
Here's the problem as I see it, and I hope I understand the zoning concept of it. If we make it a claim that we own the fee simple absolute ownership of that area, as shown on Exhibit T2 that the township has already put into evidence, then for the board to make a determination, and all I'm asking for is zoning relief. I'm not asking for title relief. But if you deny the zoning relief on the basis of a title issue, I don't know that you have the jurisdiction to do that.
I don't think we have jurisdiction if the title issue is in dispute, but the right-of-way doesn't seem to be in dispute. And the right-of-way, if you could have the fee, but have an easement that says nothing can be built on a certain area at all, okay?
Sure.
And that could be uncontested. And then I think that the board would have difficulty giving approval to build in that area. See, you're not contesting the rights that the township has here, and that's why. And I think that what you're asking for is against the township's undisputed rights in that right-of-way.
Well, the township has...
We're going to proceed. And we're going to proceed with the clear point that no decision by this board is deemed to impact the legal rights of the township and its right-of-way. And we will take whatever pains are necessary to make that clear. If it were a decision be made to grant relief, that it is limited to the zoning issue which is being posed by the appeal.
And I appreciate that, and I would agree with that.
Let's move on. Go.
Okay. Did you get sworn in yet?
No. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah, I do.
And state your full name.
I'm French, so I'm Fanny Donofrio, Donofrio.
Okay, spell your first name.
Fanny, Fanny.
And you're going to have to speak up.
Yeah, I know.
Because we're going to have to hear you and get past the French accent.
I know.
And you're one of the owners of the property?
Yes, I am.
And when you and your husband purchased the property, did you make plans or make consideration to change anything along the front of the property near the sidewalks?
When we bought the
After you bought the property, did you want to, after you bought the property, what was along the front of the property by the sidewalks?
where there were edges, but the house has been in my husband.
Sorry, you have to speak up.
Oh, okay, okay.
I'm not understanding.
Yeah, so there were edges.
Hedges.
Yeah, edges, sorry. But the property has been in my husband's family for a long time, and there were actually a fence going up to the sidewalk. So that was something that was in a house, but also in a neighborhood. And if you can see also like other property, all the fences and hedges would go up to the sidewalk. So that's like actually the character of the street.
And did you go out and look at other places when you, well, actually, did you make a decision that you were going to change the hedge and the fence?
First of all, we did a lot of planning. We even talked to the director of zoning about that.
I can't understand you.
Oh, I'm sorry.
Hold on, do this.
Do you mind if I
Come stand here by this microphone.
Yes, I suggest you use this microphone. That may help a bit.
I'll use this one, and the court reporter will be happier. Okay, so did you do any planning before you decided to change the fence and the hedge on the property?
Yes, we did.
And what did you do?
We tried to look for comparables. We went to the national park. Here is a picture of a beautiful, like, four-rail split fence in a Bartram Garden in Philadelphia.
And that's Exhibit A2?
Exactly. It's the oldest botanical garden.
I'm sorry, what kind of garden?
It's a yeah.
Don't get too close.
It's a botanical garden. It's the oldest botanical garden in the
What one?
The oldest botanical
garden in the U.S. If you want, you can repeat. I'm sorry. I should have an interpreter. So it's the oldest botanical garden in the U.S. And we thought that was a very nice comparable because it's a four-rail split fence. He hedges very well. We talked to the botanist, and he said that he actually didn't remember even like the date because it's that old. It's really part of the American tradition.
Did you also look at fences in the particular area where your home is located?
Yes, this is actually a very nice book. It's called The Mainline Country Houses. And this is one of the pictures. It's actually like our neighborhood. It's a view for Rosemont Station. Obviously, it's very bucolic.
Wait, stay back from the microphone.
Yeah.
You're too close.
It's very bucolic. It's pastoral, but again, so you can see like the 4-rail split fence.
Where does this photo depict?
I can't understand anything.
I'll help you with it.
If you want.
Where does this photo show?
It's from Rosemont Station and showing actually our street. So it's really like our neighborhood.
So you're saying, let me try to repeat it.
Yeah.
It shows Rosemont Station
Yeah, we do.
showing your neighborhood and where your street is located.
Exactly, from 1905.
And it depicts the type of fence that was in the area historically.
Yes,
And that's Exhibit A3.
yes, it is.
Now I'm going to show you Exhibit A4. Is that another photo from that same book?
Exactly,
And-
showing also our neighborhood.
And that shows your neighborhood and shows that same type of fence?
Yes, it does.
And did you consider those when you were trying to decide what kind of fence you were going to put in front of your house?
Yes, we wanted a rustic fence.
Now, I'm also showing you from the township's website, the header of the township's website. Does that show a similar type fence?
Yeah, it's actually how the community development define.
Wait, stay back.
It's how the community development define himself. They actually choose a picture showing.
So you're saying it's how the community defines itself because they actually show a picture of this four-bar split rail fence.
You have 2, you have 3, and you have 4.
In the picture you have up on the screen,
Yeah.
is that a 4-rail fence or a 2-rail fence?
You have 2, 3, and 4 at the very back. You can see you have 4 rail. It's
So
really
there's,
falling
so there's
apart.
different heights?
Yes,
Yeah.
exactly. So it's all
Okay.
the history of like the split
Okay,
fence.
thank you.
And I'm also showing you Exhibit A6. Can you tell me where that comes from?
That's actually a document from the zoning department about open space, and this is the picture they choose to just define themselves.
So that's actually from the zoning.
I'm putting nothing down.
I'm going to say it for her. I'm repeating. She said that comes from the zoning department, from the open space papers or open space documents, and it's how those documents define the township or how they define
Counsel,
themselves.
I'm not finding this helpful. The issue is the height of the fence, the location of the fence. There are no complaints about the style of the fence or the appropriateness of the style of the fence.
Then
Let's
we're gonna
move
jump.
on.
I show you Exhibit A7. Is that a picture of the front of your house?
It is.
And that fence that's located on the front, where is that located relative to the fence that had been there before and the hedges that had been there before?
The same place. We just replace it.
To clarify in my own mind, I had heard there were hedges in front of the house. There was also a fence in front of the house?
Historically, they were a fence.
Historically, there was
Yeah.
a fence. But there was not a fence when you purchased the property recently?
Oh, the property has been in a family
Okay.
since 1960.
And to the extent you know, the fence that had been there before, was it street, then fence, then hedges, or were the hedges in front of the, well,
I don't have
we
this
may get
knowledge.
that from another witness.
Yeah.
I don't want to
Yeah,
get
it's
you off
not
track.
me.
I'm sorry, counsel.
I just could talk about
Please
the
proceed.
hedges.
So that shows those.
Yes.
I'm going to show you Exhibit A8. Does that show an additional part of your fence?
Yes, it does.
And Exhibit A9,
It does also.
that's more of the fence?
It's more of the fence, yeah. Just after like we build it.
It's more of the fence just after we built it,
Yeah.
she said. And A10, is that also another photo of that fence?
Yes.
Okay. Now, and finally, A11.
Again, it's a fence showing like the street across.
And whose fence is that?
It's our fence.
Your fence?
Yeah, it's my fence.
Okay. And finally, this is from your driveway looking out?
Yes, and you can see across you have bushes. We used to have bushes like that.
The one, she said, if you look across, you can see they have bushes, and we used to have bushes like that. You should do this in French, and then I'll just...
Yeah, you should translate, yeah.
And the bushes that you had there, did they encroach out onto the sidewalk?
Yeah, they did, yeah. And they're very, very high too. They were 10 feet high.
They were very high, they were 10 feet high. Now, does this photo show the fence at the back of your property?
It does.
That's Exhibit A13.
Yes, A13, yeah.
Okay. That's all the questions I have for you.
Thank you.
I'll call her husband and give you the microphone.
Thank you.
Next time we'll do it in French. Mark, you had communications with the township, did you not, concerning getting a permit for this fence?
That is correct.
And you've seen the exhibits and the documents that the township entered into evidence in their part of the case?
I have.
And when you did that, did you, I'm going to have you look at Exhibit A14. Is that part of an email to Mr. Kachansky about the fence?
That is correct.
And did you then, subsequent to that, go to the township and have discussions about the fence that you were going to build?
That is correct.
And did you show him some, it says on the plan that you were going to show him some nice split rail fence renderings as well as a preliminary site plan? Is that,
What happened was I sent him an email, and after that I went over to the township building with my dad, and I had all these planning documents and renderings. And he came out and briefly introduced himself to me, shook my hand, and directed me to speak to two different people.
and when you say you had planning documents, who prepared them?
An architect.
And what do you do for a living?
I'm an urban designer, and I'm also a restoration contractor.
And so did you also participate in the preparation of these plans and drawings?
Yes, I'm an active client.
Okay. And Exhibit A15, can you tell me what that is?
That is a rendering and a site plan.
And is that a rendering and site plan that you gave to the township?
That is correct.
And does that depict the location of where the fence is going to be?
Yes, we're very clear in that. One of the reasons why I went to the extent to have such a detailed plan is because we were going to install a very expensive fence, and we did not want to remove our hedges without prior authorization from the township.
And this depicts the fence right out at the edge of the sidewalk?
To the sidewalk, that's correct.
And this was something you submitted to the township before getting the permit?
I did.
You were also, in addition to putting this fence in, I see to the right there are a lot of other things. I understand you were planning on putting in some type of stormwater management facility?
Yes, we want to install a permeable driveway, and these are some of the diagrams to that effect.
And the plant materials were for a rain garden?
Yes.
And that was because you have water issues on that property?
Yes, our street constantly floods, and the township hasn't really addressed any of those issues, so a lot of private citizens are trying to come up with their own remedies for the unmitigated flooding on our street.
And that's one of your plans to do it?
Yes.
Okay. Now, in addition to that, did you submit the drawings that are shown as Exhibit A15?
Yes, I was actually very clear about that.
And those show that's a particular drawing for the gate that was going to be at your front?
Yeah, Core-10 steel weathering steel gate.
I'm sorry, what is it?
A Core-10 steel weathering steel gate.
And
I want to interrupt you for a second.
Sure.
When you say you submitted these to the township, elaborate on that. I mean, in connection with what process, or how formally, how informally?
I was with my dad, and we laid out all the documents on the table. And the township chose which documents to photocopy. That's why they're showing those specific documents in their exhibits. But we actually had all these documents, and we were talking about that with two different clerks, and the clerks were going back to another person, the person who signed the actual permit.
So this was in connection with the process of applying for the fence permit?
That's correct. That's why we're kind of surprised the township went after us, because we were so forthright in the planning process.
Does A15 have any dimensions on it?
If you,
that's A15 is the gate, and I can see dimensions, but
A15 is this large plan.
oh yeah, well it's
they're connected together. We had both plans.
They're connected together. So A15, our slides are two different things, but it's the large plan, and I don't see dimensions on the piece I have up on the screen, but I'm sure was there a scale on the plan someplace?
Yes. You can see the scale in the middle at the very bottom.
Okay.
But, okay, well, then that would, if somebody was making the calculation to provide perimeter numbers for the fence, there's nothing here that would suggest the height of the fence, right?
No, we would agree with that. That deals strictly with location. And I note that on the large copy of it, it does have a scale, and it says that this is 1.5 inch. No, that's the detailed scale. It looks like about a 50 scale or something, or 40.
Thank you, please continue.
I'm sorry. Did the architect work in consultation with your fencing contractor?
No.
And was this plan attached to your application?
We gave it,
Was the plan attached to the application?
they didn't attach it to the application. Actually,
Well, you signed the application, right?
yes.
So what was attached to the application that you signed?
What happened was we showed all the plans, and the person there said, we don't want any of that. They said, we just want you to write it again in this one township document. And so I quickly wrote 4 to 6 feet in there in the one exhibit. And
No, but you've taken, obviously, a lot of time and a lot of care to prepare this. And what was affixed to the application was something from your fencing contractor that describes the job in far less detail than this does.
Well, that's why if you go back to the previous email, I was saying that we had really nice renderings in addition to a preliminary Rusticraft plan. So Rusticraft, they came up with that in like December, and after that, our architect worked on it and refined it.
So this plan, these materials post-date your application?
Excuse me?
These materials are after the date of your application?
No.
Okay, so then the refinement, I don't understand the refinement. If this and your Rusticraft contract were prepared contemporaneously, why would there be such a varying description, such a widely divergent description of what Rusticraft thought they were putting up and what this detailed plan shows?
Well, Rusticraft just had a very basic plan. Thing is, when we started communications with Rusticraft, it was in December. And then after that, we showed much better renderings because I wanted to, for example, with the hedges, they were really high. We would have to remove them. And so I wanted to be really clear with the township before we removed them, because if you have 10-foot high hedges you remove, that could cost $10,000 to replant something like that.
At the time that you went in to make the application for the fence, was this a document that you had that you put on the counter?
We put on the counter, we spoke about the documents.
And the person at the township counter simply didn't take this and make a copy of it?
We actually wanted her to, but she didn't. It was very confusing. You can even ask my dad. He was with me at the time. It was a very disorganized office, in our opinion. And we actually, I mean, I'm a really experienced restoration contractor. We go to Lower Merion, we get thousands of permits. And in this case, it was kind of odd. But we tried. We actually tried. I was emphatic. My dad can attest to that.
A16 is up on the board. Does that show the, well, tell us what that shows.
That is the 4-rail, split-rail fence, and that's the Core 10 steel gate. We had 2 different options, but we just showed one for this presentation. But if you look at the exhibits, there's one other option that shows a grid of Core 10 steel.
So is that a solid gate or transparent in any way?
We had 2 different options. The one would be fully solid. The other one would be more transparent.
But they both had the same height?
Yes.
And I'm showing you Exhibit A17. Can you tell me what A17 is?
That's the landscape concept rendering.
Is that something that, is that actually the cover page of a lot of other documents?
Yes, but we just showed one here.
And is this a document that you took to the township office at the time that you made the application for your fence?
Yes.
And did the ladies in the office copy this particular series of documents?
They thought it was overboard, so they didn't copy it.
When you say they thought it was overboard?
They thought it was too detailed for the purposes of what we wanted.
And does this...
I'm sorry, go ahead.
Yeah, it's hearsay, but...
Well, it also assumes a level of omniscience that many of us are not gifted with.
Yeah, it also goes to variance by estoppel, so that's why we raised the issue, so. Yeah, so,
I mean, we really tried. I mean, if you look, you can see all the documents tried to submit to the township, and I sent emails, and I wanted to speak to everybody in the township. You can't criticize me for not being forthright.
Did you know that there was a 4-foot height limit for fences in the township?
We were mentioning that because we said it was a split rail fence, and historically.
No, set aside
Okay.
historic split rail. Did you know there was a 4-foot limit?
I didn't think what we were doing was wrong.
That's not what I asked. Did you know there was a 4-foot limit?
Well, I asked the township, and I said, how do you define a 4-foot limit? Is it the top rail, or is it the line posts? And the people there said it was the line post. So that's the problem is when you have the extra, if you have a split rail fence.
That's sustained.
But you do acknowledge your knowledge of the existence of the limitation at the time you were applying for the application for the permit.
I thought that you were allowed to build a 4-rail split rail fence because the top rail was at 4 feet. And I thought the structural parts were necessary because the township wouldn't want to outlaw an historical type building typology. It's been part of Radnor's history for over 100 years. That was what I thought, and I asked that question to confirm that, and the clerk there said we could build this fence. That's why.
No, well,
Yeah.
okay. Let me let you continue to put on your case.
okay. And so Exhibit A17, as you said, depicts that fence at the height to which it was constructed?
Yes.
How do you know that? I'm just out of curiosity. I mean,
Tell-
there's nothing that would indicate
Height.
at all height on this.
In the application, you want to go to the height requirement?
Well, I'm going to get there, but on this, how many rails is it?
With this, it's 4 rails, but you'd have to go to the other rendering at the very end.
I'll get there. But from a 4-rail fence, do you know what height a 4-rail fence generally is?
Yeah, the top rail goes to 4 feet.
And that's,
That's correct.
okay. So you were given, you actually filled out an application for a permit that's shown as Exhibit A18?
Yes.
And that's the one that the ladies asked you just to fill out something short on the right side?
Yeah, that's correct.
And that was a 4 to 6 foot high fence?
Yes.
And did anybody tell you then that you couldn't get a 6 foot high fence?
No.
And if you look at exhibit, and you were actually given a permit for that, correct?
That's correct.
Did
Okay,
you?
quick question.
Yeah.
So you acknowledge you knew of a 4-foot limit in the front yard right-of-way,
Yes.
but you're having us also eventually get to the point where we're supposed to believe that you relied on representations of township employees that it's not 4, it's 6 in accordance with what you're applying for.
No, that's not.
No,
That's not
no.
what we're suggesting.
Okay. But he knows there's a 4-foot limit.
Oh, yeah.
Okay.
Yeah, it's
yeah,
4
yes.
foot at one portion of the property, it's 6 foot at the back.
No, I understand,
Yeah.
but I believe the application, well, the application's unclear, but certainly the implication is it's a uniform height, the entire size of the fence.
Is that accurate? Was it going to be uniform height, the entire thing? Is that the requirement?
Well,
How'd you build it?
it's uniform all the way around.
Thank you.
Okay. Now, after you build it, did you get comments from the neighbors at all?
Yes, most of the neighbors liked it.
You have some neighbors even in the room now?
If there are neighbors who are going to testify, we'll listen to the neighbors. We don't need I don't want to hear characterizations of what the neighbors
No,
have
I'm
to
just
say.
I'm going to put actual documents on. You
Okay,
received,
well, that would be fine.
you received documents from neighbors?
Yes, that's
So I'm going to
correct.
show you Exhibit A20. Is that a text message?
From the neighbors that are present in this room right now.
And it says, love your new fence, Fanny. It looks great.
Yes.
Okay. And another Exhibit A21, is that another text from one of your neighbors?
17 Arthur Road.
If it's a neighbor who's here, we'll listen to that neighbor.
Yeah.
Otherwise,
This one's a different neighbor.
is that neighbor here?
This neighbor's not here, is it? Are they?
No, she's
Then it's
not.
not admissible.
Mr. Chairman, we're,
No, we're fine. The second one of the neighbor who is not here, that's not admissible. Please proceed.
No problem. Did you take photos of some other homes that are on your street to show what the streetscape is and how the fences and hedges are along your street?
Yeah, there's a lot of historical evidence that people built their fences right to the sidewalk on our street.
And
This
that
is one example.
That's A22?
Yeah.
And A23, what does that show?
Very high hedges.
Is that similar to the hedge that used to be on your property?
Yes.
And where's that?
That's at the top of our street.
I'm sorry, excuse me. Is that a fence?
That's a
That's a hedge.
that's a hedge.
Thank
Yeah.
you.
I can mention more examples.
How did that get? I got in the wrong order. Okay. Now, also in connection with your application and the way that you attempted to develop this, was there a reason why you pushed the fence all the way up to the front, to the edge of the street?
Yes.
And what was that reason?
Well, if you look at the historical typology of our street, this is an interwar neighborhood, and all the houses have a very narrow or shallow setback. So most houses on that street have their hedges or their fences up to the sidewalk. In addition, did you want to ask the specific reason for the fence? Or?
But when you did that, is there a specific reason why you picked an open fence like that as opposed to something or maintaining your bushes?
Well, one of the reasons we built the fence is that neighbors, our adjacent neighbors, had dogs going into our yard. And one dog in particular was involved in the mauling of a Villanova student. And we were worried about that. But at the same time, we weren't personally fans of fences. And we thought that the best compromise would have been a very open fence where you could see our property, we could see out, it would improve the safety. And as an urban designer, it's very good to have unobstructed views of your personal property. For example, why do you even have like a 4-foot fence ordinance? One of the reasons why is that you don't want to have like a wall blocking your house. Another reason is when you're backing out onto your driveway, you don't want to run over people. Now, when you had like the hedges, we couldn't see anything. And if you're backing up, you have a complete view. I could keep on going on, but...
No, I don't think that's necessary.
No. The zoning ordinance doesn't make any distinction between a split rail fence and a solid fence. So theoretically, you're trying to say, well, what if it was a solid fence? Would you have a problem with it being 6 feet and in the right-of-way?
Well, the zoning code does make some distinctions between some of the fences. If you have a more transparent fence, they do mention that elsewhere in the code.
The sections we're talking about right now, are any of those other observations about split rail or open versus closed relevant here?
Yeah, the question.
They're not. They're not part of. There are other sections of the code where it's dealt with. This fence that encroaches a bit above the 4-foot line. Do you have an opinion as to whether or not that level of encroachment would be injurious to the health, safety, or welfare of this community?
It would actually improve safety and welfare.
How so?
Well, if you're backing out of a driveway, it's a lot easier to see. For example, there are a lot more kids on our street, and when I'm backing out, I can see people. And when we had the hedges before, you couldn't see anything.
And if you were allowed, if this board gave you a variance to allow you to maintain your fence, subject to the township's property rights, to maintain your fence at the edge of the sidewalk, do you have an opinion as to whether or not that would be injurious to the health, safety, or welfare of the community?
It definitely would not.
And how so?
Well, going to the sidewalk, how it could be injurious to people?
Yes.
Well, for example, our hedges were like at one section 8 to 10 feet high and had a lot of thorns and would grow out. And those hedges are actually very difficult to maintain. And there are many different examples of those hedges on our street.
Now, did those hedges encircle your property or the outside property line of your property? Did you have hedges all the way around, or was it just in the front of the house?
If you go back many, many years, it was kind of it formed like a semicircle around the property. But within like the past year, we had hedges in the front and a little bit to the left of our property if you're facing the street.
And did those hedges that you had, did they actually encroach out into the area of the sidewalk?
They did.
How much?
About 1, maybe 2 feet, as well as the other hedges on the street also have that same issue.
That's all the
If,
questions
if you had cut the hedges, they would not have so encroached, right?
I have. Well,
Trimmed them.
And
assuming that you,
Assuming you took care of your property
well,
and cut your
assuming you
hedges.
could cut the hedges, there's some that, as we all know, they reach a certain point in size that where there's nothing but dead on the inside. So if you cut them, all you end up is with brown.
I was going to say that. Over time, those hedges, they started out really like low. They're about like 4 feet. If you look at actually historical pictures from like the 1960s, now they're like 10 feet. And if you cut them, all the wood and the branches, they're dead inside.
Okay.
So you would almost end up killing the tree.
Thank you.
That's all the questions I have of this witness, your witness.
Mr. Nelson, I'm sorry, Mr. Rowley, please proceed.
you mentioned a neighboring dog causing a problem.
Yes.
How large is that dog?
It's actually a pretty big dog, about this high, and really muscular and strong.
So this split rail fence is effective, or would be effective, in preventing the dog to come onto your property?
It has been effective. It stopped a lot of those issues, and we feel safer. Actually, what happened was a Villanova student was, mauled. Her hand was bitten so badly that she had, permanent damage. And I was actually bitten by that dog at one time. And the dog would also bark menacingly at my wife, my dad, and anybody who'd come to our house. It was a problem dog, and we wanted to build a fence and resolve the issue without calling the police, because we don't really view that as calling the police as a really good solution for such neighborhood issues with dogs. And sometimes if you have an urban design issue, it can help people like coexist in the street without any animosity and the like.
Thank you. Mr. Nelson, proceed.
Is this with me or? Okay, I'm sorry.
It's going to be
I was
with
heard-
Mr. D'Onofrio, just to try to help out the court reporter, sir. Not that I wanted to ignore you.
I figured that's why I jumped right to it.
So, Mr. D'Onofrio, when did your family first buy the property?
1962.
And when did you move onto the property?
I've obtained title as of 1996.
And did your wife retain the title at that time also?
No, we recently gave her title. She's bugging me about that, so,
Okay.
I added her.
So when did your wife move into the property? Or
After graduate school,
can you give a date?
say 2009, 2010, but we actually were there 2006, and then we left it. I went to University of Pennsylvania, so then we moved to the city for a little bit because it was just too tough taking the train. The train was always late.
And Mr. D'Onofrio, Fanny mentioned a prior fence. Do you remember that fence?
Oh, I'm sorry. I thought you were asking my wife.
No.
We actually saw pictures of that fence, and we spoke to my dad. My dad, you can actually ask him the question directly.
Well, I can't ask him the question now. He hasn't been sworn. So I'm just asking you, did you ever see the fence on the property?
Yes.
In pictures or actually on the property?
In pictures.
And did you ever see the fence actually erected on the property?
No, because it was a historic picture. It was from the 1960s.
So do you have any idea when that fence was removed?
It was removed when, I can ask my dad.
No.
If you don't,
I can't.
if you don't know, you can say I don't know.
It was removed right around the time that I've got title to the property, so around 1996. It went to the sidewalk. Oh, go ahead.
Okay. Yeah, and I want to direct your attention to A15, the large plan. I think it's right in front of you.
Yes.
Isn't it true that that plan was provided to the township for just general planning purposes, that it shows a lot more work on your property than just the installation of the fence.
Yes.
And isn't it true that the fence application that's been marked as an Exhibit T1, that application doesn't match what's shown on this plan that's marked as Exhibit A15?
You're talking about Exhibit T1. Which one was that? Why would you say it doesn't match?
Because there's no indication on Exhibit T1 showing that the fence was going to be right up against the sidewalk, correct?
Well, no, Rusticraft, when they provide plans, they always provide plans that way.
But the plans, that plan, the Rusticraft plan that's part of Exhibit T1, doesn't show any sidewalk, correct?
Actually, what happened was the clerk asked me to write it in because I had the site plan, and since they didn't want to go through the whole site plan, I just wrote an arrow saying Arthur Road and the sidewalk.
But it doesn't show a sidewalk. It doesn't depict a sidewalk on that proposal, correct?
I don't agree how you're characterizing it.
It's looking at, let's see. We're both looking at the proposal contract prepared by Rusticraft, which is part of Exhibit T1 that you submitted as your fencing permit, correct? You see that?
Yes.
And in the diagram, enclosed in the box, is there anything that depicts a sidewalk or is labeled a sidewalk?
Well, you're misunderstanding. Yes.
What is depicting the sidewalk, sir?
So what happened was, when I was pointing at the site plan when I was talking...
I'm sorry. He asked a specific question. If you could answer the specific question and then elaborate.
Oh, sure. If you look at it literally, no, you don't see a sidewalk.
Okay, now if you want to elaborate, go ahead.
Okay. I can elaborate, or?
Mr. Nelson, I would like to give him a brief time to provide additional perspective on that now.
Okay.
Okay. Well, the thing is, when we were talking to the clerk, I had the site plan out, and I was explaining that we're going to the sidewalk, and she goes, just write something in there.
I'm going to object to this response. We're dealing with hearsay.
But it's the truth.
It's a zoning hearing board, and it's a township employee that we're talking about. So.
It goes right to the heart of the matter, and to be honest, it actually is completely irrelevant, because they want to make some variance by estoppel or vested right. A verbal affirmation by the township employee doesn't carry that weight. He has to provide something in writing. They have to show something. The township provided in writing, oh yeah, we know you're going to the sidewalk, that's fine. That's one thing. But a verbal affirmation from a clerk, not even the zoning officer, the cases are very clear that that's not enough to stop the township from alleging that this is improper.
If I can make this easier, that's not, the reason it's being offered is he's asking for a variance.
Use the mic, please.
Oh, I'm sorry. He's asking for a variance, and he's trying to establish that he did this in good faith. We've often seen people that just ignore everything. They just say, "I'm going to put up the fence because it's easier to ask for forgiveness."
We're going a
than
bit far afield here.
So that's,
I'm going to have Mr. Nelson continue with his cross, please.
Going back to Exhibit A15, sir. Does that exhibit show the right-of-way of Arthur Road at all?
No.
And you spent a lot of time talking about the hedges. When exactly did you remove these hedges?
When did we remove them?
Yes.
We removed them. You can't?
Yeah.
Yeah, I'm trying to think when we removed them. What I did is, when I was with my dad, we said that it's going to be really expensive to remove these hedges, so we wanted to get confirmation. We were granted the permit, and then after we were granted the permit, we proceeded to remove the hedges. If the township said no, I would not have removed the hedges. That would have been a foolish, action. And these were very expensive hedges. I mean, they've been there for over 60 years.
Going back to Exhibit A15 regarding fence height, is there any indication of the height of the proposed fence on A15?
On A15, well, if you look at our accompanying exhibit,
Now, the question's pretty precise, if you could answer the question.
I'll stipulate that there's no height on A15.
okay.
And then turning to A17, I believe that's the presentation. Yes. Is there, Mr. D'Onofrio, on A17, there isn't any indication, any actual measurement of the height of the fence on that document either, correct?
No, this is a landscape concept. It was not meant for that.
And you do acknowledge that the fence that is not within the front yard setback, that fence can be 6 foot tall, correct?
With the zoning code, from what I'm hearing now, that you could not have a 6 foot tall fence.
You could have it or you could not?
Could not.
So you're saying you, okay.
You know what, you're asking him what the zoning ordinance is, and I think we both would agree that outside of the front yard setback, you can be at 6 feet, I think. So, but
Yes,
it's illegal. You're asking him a legal question.
Well, I was just asking him what his thought process was. I wasn't asking for a legal opinion. I just wanted to know what he thought. Oh, there it is. Okay, it's all mixed up.
Do you want me to add that?
And Mr. D'Onofrio, can I direct your attention to Exhibit A22, the photograph?
A22. Can you just show me?
Here. It's this photograph.
Yes.
There you go.
Mm-hmm.
Do you know when this fence was installed?
No.
Do you know what the right-of-way is, where this fence is installed?
It would be the same as for the right-of-way around my property.
Do you know that for a fact, or are you just assuming that because it's on the same road?
Because the road is the same width all the way pretty much to the end of the cul-de-sac, except where it kind of fans out for the actual cul-de-sac. There are actually other fences. There's a 6-foot solid board fence that goes to the sidewalk. Historically, there was an English hurdle fence that went to the
Mr.
sidewalk.
D'Onofrio.
You've had the,
okay.
you had an opportunity to bring exhibits to our attention. You did a nice job of doing so, but we don't want to.
Okay.
Okay.
Mr. D'Onofrio, you also testified why it's safer to have your fence instead of the hedges, that it provides more sight distance for backing out of your driveway. Is that a correct summary of your testimony?
That's correct.
Isn't it true that if you moved the fence off the right-of-way, that would even make it even safer and provide more room to see the road and the sidewalk while you're backing out?
That'd be false, actually. It's against urban design theory.
So you disagree with that statement?
Yeah, actually, I do. If you have fences closer to sidewalk, it slows cars down in a small suburban neighborhood. That's one of the principles in a lot. Like, for example, we had a book here by Alan B. Jacobs about great streets. And a lot of times, if you have fences very close to the sidewalk, it would slow traffic down. It's actually a fact in urban design. I can say that because...
Is this road a cul-de-sac? This is a cul-de-sac, right?
It's a cul-de-sac, yeah.
Thank you, thank you.
Now, you also mentioned about the fence and the dog. Isn't it true that you currently don't have the meshing up on this fence?
We're not allowed to finish the fence until we get approval by the township.
So right now, all you have is the split rail, and you don't have the metal meshing.
No, we have the metal meshing,
Pardon?
but it's not installed.
It's not installed,
Yeah.
yes. And there's no gates installed yet, correct?
I'm sorry, I heard you speak.
There's no
There are
gate?
no gates, no. We would like to install a gate, but again, we're not going to install a gate until this matter is settled.
That is all for now.
Thank you. Do you have additional witnesses?
Well, you know what, I have a couple of other exhibits that I just wanted him to, but I forgot to have him identified. I just want to get them into the record if I can. And one of them is Exhibit A19, which is the actual permit.
Mm-hmm.
That's the permit that you got from the...
Yes, that's what I put against the window.
Exhibit A25 is a copy of your deed to the property?
Yes.
That's all.
Do you, I think you were going to update the affidavit, so that exhibit needs.
That's Exhibit A26.
Yes.
And that's when I asked Lee for, I'll send it directly to you, Mr. Ryan. I'll send you the notice that was in the envelopes and then the list of where the envelopes all went.
Okay.
I'll give you both an opportunity briefly to close after we hear from anyone else. I'm sorry, Ms. Nelson.
I would like to call Mr.
Fine.
Mr. Kochanski, you're still under oath.
Yes.
Mr. Kochanski, you heard discussion regarding the hedges on the property. Does the fact that the property had hedges on it and they needed to be removed have any impact on the location of the fence?
No, the location of the hedges would not grandfather in a location of a new fence.
And would the hedges somehow impact or grandfather in a fence that exceeded the height limitation?
No, it would not.
And are you familiar with this issue regarding the dog?
I've heard that there was a reason, one of the reasons for the fence was because of a neighborhood dog.
Yeah. And do you believe that the fence in its current location and current height would better exclude the dog from the D'Onofrio's property than one that was compliant with the zoning ordinance?
I would see no difference if a fence was compliant with the zoning ordinance, providing any less protection than what is currently proposed.
Do you know of any physical aspect of the D'Onofrio property that would lead the need to have the fence constructed within the right-of-way or have a fence that exceeds the 4-foot height limitation?
There are, to my knowledge, no special attributes to this property that would make it unique to.
And is there anything regarding the property that would prevent fence being installed that met the zoning requirements?
I saw no obstacles that would prevent the fence from being installed according to code.
Any recross?
No. Just one, I'm just double checking this. Thank you. Sorry.
Sorry, Mr. Nelson.
Yep. The fence permit was issued based on the application that was provided, correct?
Correct.
And the application that was provided, as far as you could determine, complied with the zoning ordinance, and that's why the permit was issued?
Yes, it did.
You saw the application, the additional information that was, the D'Onofrio said they wanted to submit along with the fence permit. Is that something that the township would normally accept?
The township does not turn away information in an application. We do not provide copies of information. We accept what the applicant provides, but we do not tell them to exclude something from there. We would tell them to add something, but not to take something away from an application.
So does the testimony regarding the township's review of the fence application, does that match your understanding of how the township would accept such an application?
Unless he knows about this particular incident.
I think his testimony is on the question of what he understands common practice to be, and we understand
I agree that that's the common practice, but that is not what was testified to. That's what happened.
We allowed a lot of information in that was basically hearsay. And I think I have a little leeway to provide a different view of the way this works.
I understand the question to be as I articulated it, which is what is common practice, and that'll be accepted.
Okay, thank you.
So common practice would be post what was testified, what we heard earlier. The common practice would be to accept what an applicant wanted to include in the application, but not remove anything. I'm not aware of staff ever removing something from an application.
Thank you, that is all.
So when Mr. D'Onofrio testified that he came into the office with the plans, A15, and the packet of materials that was A17, were you the person that was in the back that the ladies kept going back and talking with?
No, I actually came up and met with Mr. D'Onofrio.
So you saw Exhibit A17 and A15?
Yes, we did review those at the counter.
At the time that he made the application?
Yes.
Okay, now, when I look at Exhibit T2, and you have your Exhibit T2 in front of you, you'd agree with me that this particular property has, at least by that exhibit, a very short, a very small front yard, 31 feet front yard?
This,
It's this exhibit.
yep. According to this plan, yes, 31.2 feet.
And that's a rather small front yard, would you not agree?
I would agree that that is the front yard. For that district, it's a 30-foot front yard setback. So for this district, it's slightly larger than what the minimum required is.
That's all the question I have. One second.
One of our members has a question, Mr. Kuchansky.
Mr. Kuchansky, this is a question prompted by the cross that we just heard. You testified, I believe, that A15, when the applicant was at the counter, A15 was provided, you reviewed it.
A15 was something that we discussed in terms of long-range plans for the property. If you look at the plans, they talk about oyster shell driveways, rock beds along the property lines. Those were just a general planning, this is what we would like to do with our property. It was not something that was specific saying this is what we're submitting an application for, nor included as part of the application.
Right, so it was not included, it was not affixed to the application that was signed and submitted to the township.
That is correct.
But it was at least reviewed. I don't want to overstate. You looked at it.
It was no more than a 5-minute conversation over the permit counter window.
And the topic of the discussion was an application for a fence permit, correct?
Not with regards to this exhibit. This exhibit was the general planning of the site in and of itself, the removal of the asphalt driveway and putting in, I believe it's a crushed oyster shell or clamshell driveway, stone infiltration beds along the property line. Those were the general things that we were talking about to address stormwater management. It was, with regards to that exhibit, was not about any fencing.
So while the submission of the application for the fence permit happened at the same time as this discussion of A15, the larger planning document, the purpose for that, is it your testimony that you believe that the review of this had something to do not with the fence application, but longer range planning?
Exactly. I was under no impression that that was specifically related to the fence application, and I don't know that it was submitted at the same time. It was on the same day, but I do not know if the applicants came back later that day to submit the paperwork. I don't recall any paperwork coming across the countertop when I had the conversation with them.
Okay, thank you.
That gives me some cross, if I may. I will. Yeah, believe me, I'm watching the clock. When he was in there that day with those plans, he was there for the application for fence permit, was he not?
I don't know what he was there for, other than to discuss general planning on his property.
But he had an application for a fence permit, did he not?
I testified that I'm not sure if he had an application. I did not see an application come across the
Were you-
countertop at that
Were you
time.
not the one that approved the fence permit?
I was not.
Okay. And when you were there, did you have any discussions with them at all about this not being related to the fence?
We did not specifically talk about the fence, to my recollection. It was general planning, more stormwater management issues which were the bigger concern at the time.
Okay, that's all.
You're done putting evidence in.
Well, if it was 7:30, I would
It's not.
probably recall him, but it's not.
It's not.
And so
Okay. That being said, we would welcome any input from anyone in the audience who wants to be heard on this matter. So if you'd like to, please step forward. We'd ask you to introduce yourself, be sworn in, and if you live proximate to the property, first let us know where you live, what your proximity is to the property, and then share your perspective.
Okay, if you'll raise your right hand, do you solemnly swear to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay, and please get a microphone and state your name and spell your name for me.
Sure. My name is Lynn Fuller Schwarz. Lynn, L-Y-N-N-E. Fuller, F as in Frank, U-L-L-E-R. Schwarz, S-C-H-W-A-R-Z. I live at 16 Arthur Road, which is diagonally across the street from Fanny and Mark. Our dog is a dog that was attacked by the offending dog that lives next door to them at 11 Arthur. I'll go back to the dog story for a quick second.
If you want to state that you've had a problem dog in the neighborhood, we'll take your testimony for that.
Yeah.
And then I'm more interested in your perspective on the fence as a neighbor.
Yeah, so the dog roams the neighborhood. It's been turned in over 20 times to the township with a formal police report. There's also been a bite report that went in against our dog, which was leashed and being walked, and their dog that was off leash, off property, crossing. And Fanny and Mark have done everything that they can to keep the dog from roaming onto their property and defecating, which the owners do not clean up after. At 17 Arthur, they also have a dog and their daughter and son-in-law's dog who also roams off-leash onto Fanny and Mark's property and into the cul-de-sac, which is shared where we live because we're at the end of the cul-de-sac. This dog is also not cleaned up after and has left things on our property as well. So the fence, by going up, has stopped this kind of constant roaming of the animals in the neighborhood, which of course sets off our dog because he was attacked on leash by one of the roaming animals. So in our mind, it's been great because we're thrilled that these dogs are now contained on their respective properties by their respective owners and have to be controlled by their owners. So.
Related question, do you know whether you received the notice that was referenced?
I
at the
did.
beginning of the- do you know when you got it?
Sure, Monday.
Thank you.
Thank you.
Is there anyone else who wants to be heard? Seeing none, Mr. Ryan will assist me in who we should hear from first in terms of closure, in terms of our process.
I think that the township should go forward on the violation, but the township should be allowed to have a rebuttal at the end on the variance, because the variance is the applicant's burden.
I will actually address both, hopefully, to make it quicker. As far as the enforcement notice goes, I think the evidence clearly shows that the township appropriately issued the enforcement notice. Clearly, the fence is located upon the right-of-way, the public right-of-way. It goes right up to the sidewalk. Mr. Kachansky, regardless of whether or not the surveyor stakes are placed in appropriate positions, Mr. Kachansky measured 20 feet off the center line and found the fence to be within the right-of-way. Clearly, they're in violation of that of that ordinance provision. Likewise, clearly the fence is over 4 feet tall. Because the fact that this fence is a split rail does not exempt it from the 4-foot limitation regarding fences in the front yard setback within the R4 district. The fact that the posts arguably only exceed this 4-foot requirement does not exempt, they're not exempt. Every aspect of the fence must meet the 4-foot limitation. Nothing can exceed it. There's nothing in the language of this particular provision that gives any rise that it only applies to certain aspects of the fence and not others. This fence clearly exceeds the 4-foot limitation, and there was no evidence otherwise showing that it doesn't. Furthermore, there was clearly no evidence showing that the township was told beforehand that the fence would exceed this 4-foot limitation when it issued the building permit. The fence permit, the building permit was issued based on the application provided to the township. That application clearly showed a fence that was going to be 4 feet in this area, and it was a fence that would not intrude into the right-of-way. And that's why the township issued the fencing permit. The fact that the applicant, for some reason, thought that they could exceed this or thought that the fence could go up to the front, up to the sidewalk into the right-of-way, just because they thought it and didn't put that on their application doesn't mean the township somehow mishandled the application or inappropriately issued the permit or issued the permit in error. The permit was issued based on the application filed with it. The application showed that it conformed with the zoning ordinance, and that's why the permit was issued. It wasn't until after the fence was installed, a fence that wasn't installed in accordance with the application, a fence that was 20 feet longer on either side yard than was shown on the application, that the township then discovered, wait a second, this fence is in the wrong location. Likewise, there was absolutely nothing in the application that showed the fence was going to be taller than the 4 feet. In fact, the fence contractor clearly stated it was going to be 4 feet, and that's what the township relied upon in issuing the permit. The fact, and clearly this is something that can be easily resolved. The fence could either be cut down, the fence can be dug up, and when the posts are resunk, those posts can be sunk lower, so it meets the 4-foot requirement. We're not asking the applicant to tear down a house or move a house or something to that effect. This is a fence, and it clearly does violate the ordinance. As for the request for a variance, they put on a lot of testimony regarding this historic fences throughout the township, fences in other zoning districts, other types of fences. That has no bearing on whether or not their fence complies or whether or not they should receive a variance to make this non-compliant fence compliant. Likewise, there are arguments regarding hedges, there are arguments regarding dogs, there are arguments regarding what's happening on other properties. None of those things are relevant. The only thing that matters is what happens on the D'Onofrio property and whether or not the D'Onofrio property meets the elements necessary to be granted a variance. It clearly does not. They presented absolutely no evidence of a physical aspect of this property that would prevent them from putting in a fence in compliance with the zoning ordinance. They clearly can put in a fence that complies with the height limitations and is not in the right-of-way. There's nothing that prevents that other than they don't want it there. Likewise, there is, the fact that what they did clearly, strike that. The relief that they're asking clearly is not the minimum relief necessary. They can put in a fence that complies. That's the minimum relief necessary, no relief at all. And lastly, and probably most tellingly, is their request for a variance is clearly self-created. The only reason they need this variance is because they installed a fence that doesn't comply with the zoning ordinance. And there is a large amount of case law in this Commonwealth that clearly states that a variance cannot be granted to correct an existing violation. And on that note, I'm going to hand up to your solicitor an excerpt from a brief I wrote to the Commonwealth Court court in another matter that covers this issue. It had to do with an existing violation on the height of a billboard. So once again, it was an existing violation. They constructed a billboard with a permit that said the billboard was going to be 30 feet. They constructed it to 48 feet. They were then cited. They appealed the enforcement notice and in the alternative asked for a variance.
This would be T6, right?
Yes, that would be fine. I provide it to you because it's the same factual issue and it contains a large amount of case law and citations that may be helpful to Mr. Ryan in determining whether or not I'm correct in my assertion that they cannot ask for a variance to correct the existing violation. For these reasons, the variance request should be denied and the enforcement notice should be upheld. Thank you.
Thank you, Mr. Nelson.
Did you win at the Commonwealth Court? No.
We did and then they settled.
Well, see, that's a settlement is always good. Let's talk about the appeal first. Very simple. I'm not going to sit here and argue to you that this fence is not more than 4 feet high, that there's no proof of that. It's more than 4 feet high. We all know it. The posts are up a little bit, and the rails, you can look at the pictures, the rails are higher up on the corners of the fence, so it's over 4 feet. I'm not going to argue with you that it's not within the front yard setback because he testified that he measured 20 feet back. If he measured 20 feet back and he said it's in it, we're not saying that that's not true. Now, the third part of it, about the location of it off our property in the rear, he didn't have proof of that. He didn't really know whether those were the actual corners or whether there were other pins. And so I would suggest to you that the township did not meet their burden of proof with respect to the location of the fence at the rear. That then moves us to a variance. And this is a variance that's rather simple. It's really de minimis. I mean, let's take the two pieces of it. The height of the fence first. If you look at it, you might have a few little inches or halves of inches that go on some of the rails, and then you have the posts that go up above it. And any fence like that would look silly if they went along and cut off the ears of the posts, and it would probably not be structurally sound because the upper rail wouldn't be supported. So I'd suggest to you that the height of the fence is a de minimis matter, particularly because it is a transparent fence. If this were one of these board, a spite fence between neighbors type things, I don't think I could make that argument in good faith, but it's a clear see-through fence, and I say that's de minimis. I also, if we look at Exhibit T3A and T3C, or was it C? No, T3D, we see that the encroachment into the right-of-way is not significant. It's a foot or so into the right-of-way, just plain not an awful lot. So I'd suggest to you that that also is a de minimis variance, and I would suggest to you that even if you grant it, the township holds the ultimate trump card on that, because they can come along and do this with my clients or other people in the neighborhood who have fences up against the sidewalk and say, we don't want you to have fences within the right-of-way. This is a cul-de-sac street, though, so it's not a street where there's traffic rolling through there. And but also my client, as an urban planner, testified that when you move those sidewalks in, the fences into the sidewalks, it tends to slow the traffic down. So I look at it, there's not any safety issues to the community. There's not, the neighbors know about this. They're not over here arguing about it. The neighbors came out because they like the fence. It's something that affects that little street, and it's pretty consistent with what else is on that street. So it just seems to me to be something that is a classic example of something that's de minimis. It's a de minimis dimensional variance. And when I talk about the cases about the inability to grant a variance to correct a problem, I would suggest to you this. These people didn't do what the billboard people did. These people came into the township with rather significant plans. They put those plans on the counter, and if you look at Exhibit A15, particularly the little page of it that's sort of the second page attached to it, you will see that it does show the height of certain things. It was there. It was brought in. It was It was brought in together with that another booklet of drawings as part of the application for the permit. We all know what happened. The women at the counter looked at it and said, you know, we don't need all that stuff now. You can use that perhaps later if you have some kind of issue. Fill out this form, give us the check, and that's what happened. But these people just aren't the kind of folks that are before you asking for forgiveness because they just ignored the ordinance. And look, every zoning hearing board has folks come in with that story where they just ignore it. They say, I'm going to go do it, and I'll ask for forgiveness than permission. These people asked for permission first. They went in and showed everything in great detail. The neighbors like what's there. It just seems like it's a no harm, no foul. And in addition, the township still, as I say, holds the ultimate trump card later if they don't like it. I mean, the height, I don't think they care about one way or the other. They've raised the zoning issue on the coming out to the street. They have the ultimate trump card on title.
You, just for clarification.
Sure.
You realize that you can't adversely possess against the sovereign, so that they can't possibly,
Absolutely. I wrote a book on that
possess the
topic.
right of way.
No, you can't. Well, you cannot. Actually, you can adversely possess against the township if it's property owned by the township, not used for township purposes, like a vacant lot that the township owns someplace, and that they're not using. You could but this is not within that.
Not those circumstances.
Right.
Thank you very much.
Just take my rebuttal just on the very last point. The intention of the applicant has no bearing on whether or not they can get a variance to correct a violation. The Apple Tree decision involved a case where the builder completely accidentally built a house about 1.5 feet too close to the road. No intention whatsoever, just a mistake, an accident, and the court said, sorry, you can't grant a variance to correct that problem. It's a violation, it's self-created. That's the end of the story. Thank you.
Yeah, but this is an apple tree. This is where they came in, showed where they were going to put it in the drawings, and then put it there.
Hey, thank you. I think we've taken the time to hear both sides of the case, so we're.
Did they want to move their exhibits as part?
Yes, we move all of our exhibits.
And I think Mr. Nelson already has.
I don't
Okay.
think we have any objection to any of his.
Okay. Thank you very much.
Do you have another copy of T6?
T6?
One.
No.
Oh, yeah. No, you can have mine.
Because I need.
You know where to find it.
I know.
I need to read it.
Okay, gentlemen, anyone care to make a motion?
Choke on the last one. It's all you.
You owe me in November.
Okay.
Mr. Chairman, I'm sorry, let me get the notice in front of me here. Mr. Chairman, I move that the applicant, Mark and Fanny D'Onofrio, be denied the request, the relief that they are requesting with respect to the appeal of the zoning officer's enforcement notice dated June 18, 2018, and further that the applicants be denied their request for variance relief with respect to the fence, and that I'll stop there.
I'll second that.
All right, let's talk about it. John, since you made the motion, I'll ask you to explain why you ended up there, or if you know, as we said earlier, sometimes we make motions to get things going, so.
Yes, that motion was more for the purpose of jump-starting these discussions.
fine.
But let me talk a little bit about how I'm viewing this case. With respect to the enforcement action, it's clear what the fence is and where the fence is. I believe, with the exception of the back boundary of the property, and I'm going to talk about that separately. The photographs we've seen clearly show where it is and clearly establish that it's in the right-of-way and that its height exceeds that which is permitted by code. I think that is very, that's a very straightforward set of facts there. And the question with respect to the back boundary of the property, I feel that the township has not established to my satisfaction that the violation cited with respect to that dimension is sustainable. So to the extent that, and this is not necessarily part of the motion I made, but certainly with respect to the presence of the fence in the right-of-way and the height of the fence exceeding the permitted height within the front yard setback, I would sustain that determination in the enforcement notice, and I would strike, for what it's worth, to the extent that it is meaningful, the violation citing the back boundary of the property, because I just don't think that that's been conclusively shown to exist. So that's, I don't know if you want to take the enforcement first and then get to.
No, I mean, let's talk. I mean,
Yeah. On the second aspect of the motion that relates to the zoning relief requested, sometimes, but not very frequently, while I've been on the board, have we had to sort of figure out what happened in any particular instance. The cases where we've seen sort of a he said kind of thing, or they, on the other side of the counter did this, but I did that. Thankfully, we don't have to face those cases very frequently. But when we do, it's incumbent upon us to find some facts before we start applying the law. I frankly don't know what happened at the counter. A15, the very extensive architectural plan that was presented, had a lot of stuff going on with it. And that plan, in juxtaposition with the Rusticraft diagram on the application, they were like night and day. And I'm not really certain how the two can be said to have coexisted, I guess, is my issue. I mean, the Rusticraft, it's a square, it's got some dimensions on it, doesn't have anything else on it, boom. And I do believe that that's the diagram upon which the building permit was issued. There was a lot going on A15, and it showed the location of the fence right up against the driveway. But I don't know that that particular fact or anything relating to the issue of the fence in the front yard setback was ever the topic of conversation at that counter when the application for the building permit was submitted. So I have trouble getting my arms around the argument of they knew what was going on. I can't get there on the facts that are presented in the record. And that being the case, and the testimony also having shown that the applicant was aware of the 4-foot limitation in the front yard setback, it leads me to believe that there perhaps was confusion in the applicant's mind as to what was going on at that counter and the effects of having a very detailed planning document next to a very rudimentary fence permit application, what that would mean for the process that was started when the application was submitted. For those reasons, I cannot get my arms around granting the variance for a condition that the applicant created itself. And that's ultimately where I would deny the relief that's requested with respect to the zoning variance, and as I've already stated, sustain a portion and strike a portion of the enforcement notice that was prepared. And this is probably the last time Bill Martin lets me talk first, because I just filibustered. Sorry.
No, not at all. My perspective is a little, I'm just coming at it from a different place, which is I'm trying to balance, on the one hand, the applicant shouldn't get an advantage because they've done something and imposed the circumstance that we're now addressing. On the other hand, I think it is appropriate to ask yourself what you would do if this was the applicant coming in, there wasn't a fence there, they came in and said, we want a variance, this is why we want a variance, and this is what we want to do. And I think if that was the case, I would say that the height of the fence is de minimis, but you can't have it in the right-of-way. And I think that the other benefit to me, again, on the one hand, they should not be benefited by having done something. On the other hand, there are realities. And there are realities of money that has been spent. And, you know, we can end up on a continuum in terms of level of good faith versus mainly good faith versus who knows versus bad faith. But, you know, we'll all come up with where we are on that. But I think if I was sitting as a board of one right now, that's where I would end up, which is sustaining the notice, because as you indicate, the notice on the 2 of the 3 points is accurate, only granting the variance as to height because it's de minimis, and they would not have zoning relief on the location of the fence, and that front fence would have to be moved. That's my opinion.
I think that I struggle with doing the work before it gets done. And what I struggle with is this is a very structured process. Having gone through it, you know, in work and stuff, things aren't usually left to chance. And so for me, I think it was kind of deliberate. I think because there's some passion with the applicant's profession, it was a kind of a thing where I'm going to put it up front because it smallers the street. And I think the noise with the hedges, what did I read? I think in 1968 is when they actually enacted some of the rules before the hedges were probably even built. Things change, and with those changes, you have to comply with what needs to be done in today's being compliant. I think being de minimis, if it has no value, then why wouldn't it be the right height to begin with? Whether it's 5 inches high or the fact that it's not the right height, it is de minimis. I mean, it should be the right height whether there's viewing or not. I think it was deliberate. And so I struggle with making the work done and then coming back. Again, he said, she said. I don't think this is the first time the applicant's gone through this process, meaning it's part of his work. He kind of knows the details. And I kind of agree with the 2-plan thing. We're very anxious to get the information because I know the township wants to get stuff done and they're not looking to jam anybody up. So I think that the fence should sort of be moved back, and I think it should be to code. At the end of the day, I don't think it's a big deal. And so I see where it was pretty much kind of a stalemate, and we're going to do it, and if you don't support it, we'll take it to the process. And I think it could have been rectified in the very beginning, and it was done with the intent to sort of fight it at the end. So my support is to not support to support the enforcement notice that it has to be changed.
There is a motion on the table, and there's been a suggestion as to an amendment. which one member is not sympathetic to. So at your suggestion, we could either proceed to a vote on the motion as it stands, or we could consider any amendments to that motion.
And, Mr. Chairman, the amendment to the motion would be to retain the height of the fence in the front yard setback, but to move it out of the right-of-way?
Correct.
I would be fine with that amendment.
Okay, so the motion, to clarify this, and John, make sure that you're not confused, because you're going to write this up, is that we are sustaining the violation notice and granting zoning relief granting a de minimis variance as to the height of the fence as it currently stands per the evidence in front of us. But we are not granting relief regarding the location of the fence in the right-of-way. So as such, that violation would continue to exist.
And let me just add, if I read your motion correctly, you're not saying anything about possible encroachment on private land on the sides, and that the order would not purport to speak to that.
Correct. The motion as I made it was to uphold those portions of the enforcement notice that spoke to location in the right-of-way and height in the front yard setback only.
Yeah.
And saying nothing with respect, well, I would modify the enforcement action to remove any reference to a violation at the back border of the property.
And the decision would be written that there was insufficient proof on that, and that nothing in the decision is intended to alter the actual rights of the various parties on the ground. Just
that's right.
Get it out of the right of way.
Okay, so with that amended motion, I'm going to call for a vote. All those in favor of the,
I'm sorry, did we second the amendment? Or do we have to?
If we have to, I'll second it. So the amended motion is being called for a vote. All those in favor say aye.
Aye.
Any opposed? No. The amended motion passes 3-0. Thank you all for your time. The meeting is-
Can I just ask, the township needs a clarification.
I can't hear.
The township, this could be off the record. Township wants a clarification based on your vote. So if they move it, they can move it and keep the current height, correct? They don't have to reduce it to...
Correct.
Okay, great, thank you.
Correct. All right, meeting is adjourned.
Thank you, gentlemen.